The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oh yay, oh yay, oh yay. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, counsel. We're happy to have you with us, and we're happy to hear argument in our first case, 2011 Wood versus Sterling. Ms. Franklin Best, whenever you're ready.
Good afternoon, Your Honors, and may it please the court. Everyone must concede that the majority of the state's case for death against John Wood consisted of inadmissible prison conditions evidence. The only question before this court, and what the PCR court got wrong, is what effect this evidence had on the jury. Here, we had a jury that was in equipoise, and the introduction of this inadmissible evidence and then use of this evidence in closing argument prejudiced the petitioner. Now, the core error the PCR court made, and which permeated its analysis of petitioner's claim, was that it treated this case as an overwhelming case for the death penalty. In so doing, it committed a number of legal errors that rendered its adjudication unreasonable. So, for example, the PCR court found petitioner's prior prison record to be aggravating without recognizing that he had been safely housed during that prior federal incarceration. The court discounted the mitigating impact of that prison adaptability evidence. Also, the court improperly discounted petitioner's mental health mitigation evidence when it found that evidence was, and quote, without findings of psychosis or delusion at the time of the offense. This nexus requirement imposed by the PCR court, of course, violates Tenard versus Dredke. The PCR court's order was signed 3 years after Tenard was decided. The court unreasonably found that, as to conditions of confinement evidence, that the defense was able to, quote,
Ms. Franklin Best, I'm sorry, Judge Diaz here. Can I take you back just to what you said earlier, that it violated a case that you cited whose name I've already forgotten. So what's the upshot of that case? What do you say that the PCR court got wrong?
So Tenard v. Dredke is the case that I just quoted. And that was the case out of, I believe it was Arizona, where they held that the mitigating evidence wasn't relevant unless it actually went to kind of the circumstances of the crime. So, I mean, if you could show that. Well,
can I, so I don't think the PCR court said it wasn't relevant. It just sort of was, to my mind anyway, commenting on the strength of the evidence, given the rebuttal evidence, the expert rebuttal evidence that had been presented by the state. Do you see it differently?
I do, Your Honor. I mean, you know, he seemed to make sort of an explicit finding that unless there had been psychosis or delusion at the time of the offense, that mental health evidence was not particularly mitigating. I mean, so he discounted it in a way that was
in the point of that, the particularly mitigating point that, you know, he's entitled, you can't ignore it under Tenard, but it seems to me that the court can say it's less persuasive, right?
Well, but he didn't do that. I mean, what he sort of found was that there needed to be this, you know, this direct kind of connection. I mean, he didn't make the claim that he found it to be less powerful because of that. And in fact, he didn't mention throughout the order any of the other kind of additional mental health evidence that had been presented on Mr. Wood's behalf. You know, Mr. Wood put up a case that was highly dependent on this mental health mitigation evidence. And, you know, the jury, for example, asked to rehear that during its deliberations. And that is just an aspect of the case that the judge here just completely ignored, discounted. And so
do you say that he used both words, and maybe it doesn't matter in your mind, but do you contend that he ignored it or that he discounted it?
Well, I mean, I believe he did a little bit of both. I mean, he discounted it by sort of referring to it in this very limited way, finding that, you know, the psychosis or the delusions did not have anything directly related to the offense, you know, the offense of conviction. But there was much more that the court should have considered in this case.
Counsel, do you have other arguments?
I do, Your Honor. The court unreasonably found, as to the conditions of confinement evidence, that the defense was able to, quote, score as many points, if not more, than the prosecution. This finding is not at all supported by the record. A fair reading of the record is that the state elicited evidence to show that a life sentence would simply be a change of address for the petitioner, and that he would have canteen and movies, books and magazines, and work and educational opportunities. Life in prison just wasn't going to be an appropriate punishment for the petitioner. This evidence didn't benefit John Wood, and the statement again sort of highlights the unreasonableness of the judge's order in this case. I mean, prison adaptability evidence is clearly admissible and mitigating evidence under a long line of cases, Skipper v. South Carolina, Lockett and Eddings. But the prison conditions evidence is inadmissible under established South Carolina law. That was true at the time of this crime, or this trial, excuse me, and it remains true today. Now, here's how we know that the jury was in equipoise. They deliberated over a 3-day period. They received an Allen charge from the judge. They requested to rehear the mental health testimony of Dr. Schwartz.
So, Ms. Franklin-Best, can I, with respect to that, and you just made the point that I was going to make, and you made it earlier, that there was apparently some interest in the jury in understanding the nature of the mental health evidence. At least we can surmise that. It's hard to know exactly what a jury is thinking, but that would seem to make some sense here. So, how does that seems to cut against the notion that somehow this conditions of confinement evidence was central to the prosecution's case? So how do you respond to that?
I'm sorry, Judge Diaz, I don't think I quite understand the question.
Well, the question is, you're making the argument that the conditions of confinement evidence essentially just overwhelmed the case in mitigation and was a central component of the state's case. And part of that, I guess, the argument you're making is that this was a close case because of the fact that the jury focused on this mental health evidence. But if it was close, it wasn't because of the conditions of confinement, or at least the argument is it was because of something else that was relevant to the jury, and that this really wasn't an important part of the prosecution's case. Do you see my point or question? I don't know if that's a question or a statement, but.
Well, I think I do, Your Honor. And let me just sort of mention this really quickly because I do not see the timer up on my screen.
You've got 7 minutes.
So somebody may just sort of need to tell me. But I mean, so this prison conditions evidence constituted, I mean, it just was the case for death in this case. I mean, it was about 55%.
Is that really fair? I mean, there was a pretty compelling case in aggravation related to the circumstances of the offense. The victim's wife testified. The other officer who was injured and shot testified. There were other witnesses, eyewitnesses who testified. So I don't think it's really fair to say that the conditions of confinement evidence was sort of the be-all and end-all of this case, is it?
I believe it was, Your Honor. I think a fair reading of the record, when you look at the argument, I mean, the introduction of that evidence from Sly, who was the state's witness, who they brought in. This is the same witness that they brought in Burkhart, which is the South Carolina case that got reversed based on this testimony. It constituted just sort of the heart of their case. I mean, they had a couple of other witnesses who testified to sort of the specific facts of the crime. You did have the widow who also testified as well. But I mean, the case, and they brought it home during the closing argument when they, argued that if you give John Wood a life sentence, it's going to be nothing more than a change of address for him. I mean, this just was their argument for death. So I guess I disagree with.
Can I go back to Judge Diaz's original question, which was a question I had too? and I'm not sure you've answered. You spend a lot of time talking to us, which is a fair thing for you to do, about the 3 days that the jury took and how it seemed to be so disturbed, but then you immediately went into, they asked questions about mental health. So are we to take from that the logical conclusion that what they were disturbed with was the mental health disease and what that would do for the defense? Or do you make some argument that we should also be considering that in figuring out whether they were disturbed about the conditions evidence? Do you believe they go hand in hand? And if so, why?
I mean, Your Honor, I do. I mean, I think
well, okay, you do. Now why?
Okay. Well, what Strickland requires, is that the court consider conduct a fulsome, objective inquiry into the entire record to assess prejudice in a particular case.
Right, but maybe you're not understanding me. We look about these days, and we look about the jury being undecided, and you brought up the question that they kept worrying about mental illness or the mental illness testimony. And what I'm asking you is, do you think that that's any indication that they were worried about the prison conditions evidence? The 3 days they took the inquiry? Yes or no?
I mean, and I guess I just need you to sort of I guess I'm having some difficulty just quite understanding the question. And so I apologize.
Okay. Well, let me just start. I'll ask a backup question. So you have an argument about conditions, right? And the improper argument that you say that the state made with respect to conditions. And that it wasn't brought on by, can you not hear me?
I'm having difficulty hearing you, Your Honor.
Jeezy peasy. All hell is
crazy.
Can the rest of you hear me? No?
Occasionally it gets muffled, and it may be that
I think it might be the storm here. We're having a big storm as I
You're
speak.
good now. You're good now.
Okay. All right. I'll try to stay in this particular position. Okay. So I'm focusing just on the conditions.
Okay.
Your claim that the conditions testimony was improper. And I had thought that maybe I had misunderstood what your argument had been up to this, that the fact that the jury seemed so deadlocked was helpful to you in making that argument. But in oral argument here, I thought you tied the jury's length of time in considering the issue only to the mental health problems. So what's your argument?
Well, I mean, I think that the jury was interested in in the mitigation that that counsel gave to them, which was this mental health evidence. And so I think that being the case, when you infect the trial with this prison conditions evidence that is arbitrary, that is irrelevant, it tips the scale in favor of a death sentence. I mean, so it undermined the jury's consideration of that mitigating evidence. So that's the relationship between the two, Your Honor.
All right.
So, Strickland requires the court to conduct, as I said, a fulsome, objective inquiry into the record to determine prejudice in a particular case. The court is obligated to assess errors to the extent that the record permits to determine prejudice. And a court cannot just ignore evidence that strongly suggests that the errors impacted the jury's verdict. And here, Your Honors, the PCR court did just that. By beginning with the assumption that this was an overwhelming case for death, the PCR court's analysis did not properly assess the aggravation and mitigation offered in this case. It failed to conduct a searching inquiry into the record to determine the harm caused by the introduction of the improper prison conditions evidence. The court's adjudication was unreasonable. Fair-minded jurists could not disagree it was unreasonable, and petitioner respectfully asked this court to grant relief. And I do not see how much time I have, Your Honors.
You have about a minute.
Okay.
You can reserve for rebuttal if you wish.
I would like to reserve that if I could. Thank you, Your Honors.
Thank you. Ms. Brown?
Thank you. Good afternoon. May it please the court. Melody Brown, for the respondents in this matter. This is a 2254 case appeal, and this court has already narrowed the focus of the appeal to one issue, an ineffective assistance of counsel claim regarding the prison conditions, as we heard a few moments ago. But I would suggest that it can be narrowed down even further, and that is that the inquiry, the true inquiry before this court, whether the petition was reasonable. Was it reasonable application of law? Was it a reasonable application of the law to the facts of that case as the facts appeared before the PCR court? And we suggest absolutely that this is a reasonable application of the Strickland prejudice standard. Now, I switch directly to prejudice because the order is quite clear from the state court, though not a basis for it, the conclusion that there's sufficient performance. So we go straight to prejudice. And Strickland, of course, controls. I don't believe that there's been a question that Strickland controls. Now, there's been some suggestion that Burkhart and even 16.325 would indicate sort of overwhelming prejudice, an assumed or presumed prejudice when condition evidence comes in. And that is not a correct statement of state law. And the state law at issue now that's clarifying is the Bowman v. State case from 2018. That clearly states—
Counsel, just to help me understand why this argument matters, in the question of whether there's a federal constitutional violation, don't we look to federal prejudice under Strickland? And so even if state law had some provision in it, we can't grant relief based on a state law ruling, right? We only grant relief based on federal constitutional rules, and that requires us to apply Strickland, right?
Absolutely correct, Your Honor. I do think looking at what the PCR court looked at, which includes some of the 2018 cases that I had referenced in the brief, shows that the court did not simply skate over this. It shows a reasonable consideration of all the elements and facts before making that decision. The ultimate decision, of course, is prejudice under Strickland. You're absolutely correct. But I think it shows that the court considered this. And the order also reflects that the court very carefully considered all of the other evidence in making the prejudice analysis, as Judge Richardson pointed out, under Strickland, which is controlling. And he took every element and considered it, considered the elements in aggravation, considered the mitigation case, considered victim impact evidence. And I believe there was a suggestion earlier in the argument that the judge discounted mental health. But if the court would take notice of the exact wording in the PCR court's order, the PCR court says mild evidence, which is a qualifier, which means it's not discounted. It wasn't cast aside. It was not given much weight. And again, under Strickland prejudice analysis is a balancing by the reviewing court, in this case, the PCR court. And he took all of that evidence and considered whether there was a reasonable probability of a different result. Now, the type of evaluation was very complete, and the rule was Strickland, which was properly applied. That's a reasonable application of federal law to the facts of the case. And we need to go no further than that. But in this—
Ms. Brown, can I ask a question about part of the order that has to do with the PCR court's analysis of prison adaptability evidence and conditions of confinement? Excuse me. The question I have is whether or not the PCR court made a correct distinction, because the court seemed to suggest that part of the defense's calculus and whether or not to allow the conditions of confinement evidence in was the possibility that if they chose to object to that somehow the evidence of adaptability to prison wouldn't come in. And of course, well, you could tell me what your position is, but I think that there's a distinction between the two. One is clearly admissible, the other one is not. And I wonder if the PCR court lost focus with respect to that issue.
I think two things tell us that it did not lose focus. One is that this is not deficiency where somebody could have made a strategic decision. This is prejudice. And within prejudice itself, you're looking at the impact that that evidence would have had on the totality of the circumstances and particularly the impact on the jury's deliberations. So taking the fact that it is in the prejudice analysis itself, this is not a determination of whether it should come in. This is a determination of how it impacted the proceedings, which is exactly where it should be. Now, I agree with you, there is a distinction, but I would further submit that distinction is difficult to draw sometimes. And I think it's also very important to remember that the judge was looking at the context of the entire case. This means state and mitigation presented by the defendant. And the defendant was going to present some portion of conditions through their own witness, James Aiken. Because if the court will review in detail that particular passage of James Aiken's testimony, he does talk about classification and adaptability, that sort of thing. But then he goes on to describe the cell, the living conditions, and even says at one point we can control them. And defense counsel echoes that in his closing, saying that, they have the ability to control him. So that line is blurred.
Right, but that isn't that all in response to the initial introduction of the evidence? I mean, at that point, they have to make the best case they can make, and the best case is trying to rebut what should have been inadmissible evidence to begin with.
Well, I would turn back to what the PCR court resolved after looking at both the trial record, contemporaneous trial record, and what PCR counsel testified to in the collateral proceeding. First of all, the trial court record shows that this was not a surprise, but in fact, the state said, this is the witness I'm going to present, and this is the reason I'm presenting him for the conditions. And counsel went back to co-counsel. They had a huddled together moment, talked about it, and then said, we have no objections, and said specifically to the conditions evidence coming in.
Counsel, does it matter in the context of Judge Diaz's question, does it matter that the defense counsel argued in the opening statement that the miserable imprisoned life is worse, more punishing than death?
I think that is more evidence.
Help me understand what I'm having a little hard time understanding exactly what I do with that. It seems relevant, but I can't figure exactly where that fits in the analysis. And it might fit where Judge Diaz is asked, but I'm not totally sure of that. What do you help me understand from an analysis perspective, not a 30,000 foot gut feel reaction, but within the Strickland analysis that we're looking at, how the fact that the defense raised this initially in the opening statement, that the miserable imprisoned life is worse than death, how that plays into our legal analysis.
I think there are two ways to look at it. First is to look at an interpretation of what actually happened at trial. Now, the solicitor mentioned that defense counsel made that argument, and also mentioned that there was movement with life without parole instructions, and also voir dire as a basis for offering the testimony. So that the opening statement was mentioned in that respect. And then counsel after that says, oh, I'm not going to object to the conditions. So what you have is sort of a pattern that this was intending to, that defense was intending to have this come in all along through James Aiken. Wouldn't have made the opening statement if there wasn't going to be some evidence presented. I think that's a fair assessment of the record. I think that contemporaneous record is very influential with the PCR court's decision that they thought that they could have an advantage in cross-examining Mr. Sly. That's part of the...
But is that only, and I guess this is maybe the part, and I don't want to take up too much time on this, but so all of that seems to go to the performance piece, which we're not really addressing here, right? I mean, one might have decided, I guess, in the PCR context, that this was a strategic decision to let all this in. And so it was not an effective assistance performance-wise. But that's not what we're addressing, right? And so what I'm trying to understand is what do we do with this piece, the defense's initial introduction of how bad prison is going to be as a mitigator, just pure prison conditions, right? The miserable imprisoned life, how that plays into prejudice. And I thought you were going to talk about, this is the PCR point about, which side scored more points, right? And so it's sort of that, this is evidence that suggests that maybe the defense, at least ex ante, believed that they were going to score more points than they were going to lose. And that's some evidence that supports the PCR's ultimate conclusion.
Yes, sir, it does flow into that. And I think you're absolutely right. It can go to the first prong. But
You're going to adopt the argument.
the second prong, however, part of that is, was the defense really surprised? So might I suggest looking at it from the view of they were already going to introduce evidence. And that's the type of context the PCR court was looking at when it resolved counsel apparently believed they could score more points on this issue. That's the part of the decision to object. It also flows into whether this was some kind of constitutional violation because the defendant didn't have the ability or the process to respond to this evidence. It was not a shock, and that kind of figures into it. So I agree with Your Honor, it could go to both prongs. I think in this case, it shows the continuity of strategy that even we didn't get that from defense counsel. Defense counsel essentially told us he could not remember why he did what he did. But his conclusion that it was error was based on cases that came out far after that. But we also don't have to go.
Excuse me, counsel, you don't assert that it was an error for this evidence to come in, do you?
We do not contest the first prong. It was deficient. And I don't think we have to look far to make that determination. We can follow this court's ruling in Sigmund versus Sterling. This is almost the exact same issue. So we already have a roadmap of exactly where to go with this. Was Plath out there? Yes. Was that considered not to be admissible? Yes. But keep in mind too, that the trial judge in this trial actually did find it was admissible. So there was a ruling on admissibility, and that was not challenged by defense counsel either. Plath was there, defense counsel could have challenged, but we're not saying general prison conditions should be admissible. I don't think that anybody has argued that, nor should they, based on the way that South Carolina law reads. Now, the problem is that prohibition, does that mean that there's some kind of inherent heavy prejudice with it? No. And that's where we look at the context of what happened. And it's rather interesting when you look at the Sigmund
Ms.
case.
Brown, and does that context include the point that your colleague on the other side made about how this seemed to be, at least in her view, the principal focus of the state's case? I think the brief mentions that the state spent 27. If she didn't mention it, I think the record would support the notion that there were 27 transcript pages about questions regarding prison conditions and made up more than half of the testimony, et cetera, and that the prosecutor focused a good bit of his argument, the solicitor, in closing on this very topic. And it's difficult to gauge, obviously. It's hard to figure out exactly what gets a jury's attention, but that is concerning, isn't it? That, I mean, he sort of likened prison conditions to spending time in a mini city with restaurants, and I mean, he made it sound like it was just a paradise, and it clearly is not. And so how are we supposed to weigh that, or how was the PCR court supposed to weigh all of that?
Well, I think that the PCR court's order shows us that he went into all the evidence again. I think to look at only what was presented artificially cuts off half of the case. At the very beginning, of the penalty phase, the solicitor moved in all the evidence from the first phase. So everything that happened over those days of trial, all of that individualized testimony on the crime itself and how Mr. Wood acted during all of the offenses and all of the danger and the injury that he inflicted, all of that came in. And we see in the PCR court's order how he went back and looked at that, the wild chase, the wounding another officer, running civilians off the road, commandeering a truck at gunpoint, gunfire, endangering other officers and civilians. And then he goes on to look at victim impact, which was only in the penalty phase. And then, of course, the mitigation, where he weighed the mitigation as well. So all of that is together. It can't be separate.
Well, maybe, but aren't we looking at, we just have a challenge to the penalty phase, right?
But that evidence is adopted into the penalty phase. So
Well,
it expands
thing, but it's a different jury, is it not? Maybe I'm mistaken.
It is not. It is not. It's a fact of about
Same jury. So the jury's heard that evidence, and now it moves to the penalty phase, where I don't think it's disputed that the bulk of the state's case in the penalty phase was improperly admitted, improperly given by the state. Do you dispute that?
I do not dispute that it was, in hindsight, improperly admitted at the time.
Well, is that the law that we are to apply?
Well, the ruling from the trial judge was it was relevant. So we do have that. I do not think it should have been a relevancy ruling based on our later cases and the clarification. And if it's tried today, Your Honor, certainly it would be found inadmissible.
Well, what rule applies to our review of it? Is it admissible or inadmissible as we look at it?
The only thing that applies would be the Strickland test, which is deficiency and prejudice.
Okay.
And the way that we would look at prejudice is it's a subjective consideration. And that brings me to my last.
Is that evidence admissible or inadmissible as we sit here today?
In your evaluation, it would be considered as extracted and it was reweighed.
It was inadmissible.
And the prejudice.
It was error to admit it. Okay.
Yes, I believe we would be on the same page with that, Your Honor. And as far as the jury determination, I think that some courts have looked to jury deliberations. I believe it was Judge Diaz that mentioned that there were notes that came out and mental health evidence, portions of the testimony from several witnesses were replayed. But at the end of the day, a Strickland prejudice analysis is an objective analysis of the evidence and what a particular jury did and what a particular jury found important or not important. First of all, almost impossible to know, but it's not evidence in the case either. So it would actually be contrary to Strickland, and this is what the district court found. It would be contrary to Strickland to try to, first of all, say that that's evidence that goes into a Strickland analysis, and certainly to try to guess what it means. So
well, last year we did exactly that. We did consider the delay that the jury, the length of time that their jury spent, and it was less than the time here. And we considered that and ruled for the defendant. So I'm just not, I don't think I track all of your arguments.
well, I think maybe I do understand where you're coming from, Your Honor, and that is
Good.
you can consider it, and judges have considered it before. There is not that that's never been considered before, but under AEDPA, it's an unreasonable application of federal law as interpreted by the Supreme Court.
Why don't you look at Williams versus Sterling? See what you think about that.
But there's nothing that shows under a Strickland analysis that it must be done. And that's where the district court found that little bit of a difference. And
well, we found it error when it wasn't, when that fact, in considering that there was, we were giving relief, we considered the fact that the jury had been deadlocked for 2 days.
And the jury can be deadlocked and they could consider it, but a judge looking objectively at the evidence may not find that it's that close. And that's the difference. And since we're under Strickland, it was an appropriate evaluation.
All right.
And I see that I'm almost out of time. May I answer any other questions from the court? Thank you very much. I appreciate your time.
Thank you. Ms. Franklin Best, you with us?
I apologize for that, Your Honor. May it please the court. I mean, right. I mean, the critical question in this case is whether or not the PCR court accurately assessed prejudice. And when you look at this order, I don't believe there can be any question.
Is it accurately or unreasonably?
Well, unreasonably, Your Honor, would be the standard. Yes, Your Honor.
Because I think, you know, and I don't say that just to trip you up, because it could be the case that a judge could think that if he or she would have been in that position, they might have ruled differently, but that isn't the test, as I understand it. We have to, I mean, we can't just indulge our predilections. So I just want to be clear about what the standard is.
Well, and I apologize for my unclear language. I mean, it was objectively unreasonable. And we know that by looking at the order. We know that the judge really sort of on a very deep level conflated, you know, the evidence of prison adaptability and the conditions of confinement. And when you look at the language that he uses, you know, he talks about how James Aiken, which was, you know, there for purposes of showing prison adaptability, how in many respects he traveled down the same road as Mr. Sly. I mean, he didn't, you know, and as Your Honor pointed out earlier, I mean, there was a little bit of response to the improper evidence that was interjected by the state, but the evidence is completely analytically different. I mean, the prison adaptability evidence is clearly admissible, it's clearly mitigating, and the prison conditions evidence clearly is not, and was not at the time, remains the case today. So looking
Counsel, can you address the defense's argument in the opening in this line about you know, where I seem to have lost it, but where they said that in essence the horrible prison conditions is worse than death? Is that conditions of confinement? Is that a conditions of confinement argument that was made in the opening?
I mean, I believe that the counsel in this case, when he started off his opening argument for the penalty phase, made a reference to, you know, here we are going to talk about penalty, which is going to be either life in prison or it's going to be a death sentence. Now, by saying that, he did not invite the state to then, you know, introduce this enormous case for.
But he didn't say that there are these two options, right? I mean, what he said is the miserable imprisoned life is more punishing than death, right? I mean, that's making a value judgment that is talking about the relative impact of prison conditions versus the death penalty. I mean, that to suggest that there are two options. I mean, that seems to misstate what was actually said. And if you want to, you know, not answer it is fine. But what I'm trying to understand is, given what was said, what impact that has. And I think ignoring it doesn't help answer that question.
Well, I'm not ignoring it, Your Honor. I mean, what he said was a far cry from the idea that there were going to be a restaurant in prison, there were going to be movies, there were going to be books and magazines, there were going to be children sitting on his lap.
Counsel, I think everybody would agree with that. I had read that earlier statement as they're both terrible, and sort of like you're going to get one or the other, right? So it wasn't entirely inconsistent with the much more fully developed argument about what prison conditions were.
And that's correct, Your Honor. And at the end of the day, I mean, the PCR court did find that the introduction of that evidence was inadmissible. It was deficient performance on the part of counsel. So, I mean, that's where that issue sort of ends up.
Yes, but we're talking prejudice here, right?
Yes.
And then you
Yes.
go back to my colleague's question. Well, was it so prejudicial if defense counsel said this? And that's what I think we wanted you to answer.
Well, I believe that sort of those very limited statements at the beginning of the penalty phase were not prejudicial to the extent that the state's fulsome case on prison conditions in attempting to seek a death penalty, how prejudicial that was. And I feel like I've left you. So, but I do want to say, I mean, in assessing prejudice in this case, you know, it's not impossible to do in this case. I mean, when you look at the actions of the jury, when you look at the fact that they received an Allen charge, that there were 3 days of deliberations, that they asked.
That again, are you making the argument that one of the reasons that the jury took so long and had so much difficulty was because of the evidence that you're arguing about now, the prison conditions evidence, or is it because of the mental health evidence?
I believe that a fair reading of this record, Your Honor, shows that they were concerned about, I mean, they were carefully considering the mitigation case that trial counsel put up. And with the introduction of this improper evidence, that swayed them to disregard the mitigating evidence and to impose a death sentence.
And how, I know that's your argument, but where do we find that? What support do we find in what the jury asked for that? Because I thought you earlier said that this was all, the questions were all about, can you not hear me again?
I'm having difficulty, I'm sorry. Sorry,
I thought
Your Honor.
the earlier response to us was that the questions were all about mental health from the jury.
And I believe that they wanted to know about, I think they were carefully considering the mitigation evidence that was put up by counsel. And, you know, that being the case, the introduction of this highly improper evidence moved them to a death sentence, whereas in the absence of that evidence, they most probably would have come back with a life sentence. And I do not see a clock. I just, again,
you're over time, but I'll ask my colleagues if they have any questions. You're 2 minutes over.
Oh, I'm sorry, Your Honors.
All right.
I apologize.
I don't hear any questions, so do you want to conclude in about a minute?
I would just respectfully ask this court, Your Honor, to consider our arguments and to find prejudice in this case and to grant John Wood relief, a new penalty phase. Thank you, Your Honor.
Maybe you could ask the clerk to be sure we have the timer up for the lawyers. Is there a problem with that?
The lawyers each individually have to make sure that they're in gallery view to see the clock. I'll check with the next counsel coming up. Thank you.
Thank you very much. Counsel, we appreciate your arguments. I think we have no further questions. Thank you very much. I think, yes. You turn your computer off so we can see the.
Join us. Can you both see the clock?
Can.
Yes, we can.
Great. Thank you so much.
Thank you.
Mr. Walsh, you with us too?
I am, Your Honor.
Are you? Oh, there you go. Perfect. Okay, we're happy to hear argument in our second case in reapplication of Newbrook Shipping Corporation. Mr. Walsh?
Good afternoon, Your Honors. May it please the court. We are here to argue about a discovery matter that's basically been involved in global litigation. The parties that originally were involved in this case are companies that are involved in litigation in South Africa, involving the arrest of 2 separate vessels over there, as well as arbitration in Singapore. During the course of the second one of those arrest proceedings, they've brought the appellees in this case have brought this litigation to the United States shores, attempting to get some additional discovery in this case from one of the agents of Nadella, which is the other party in the cases that are pending in South Africa and in Singapore. They've tried to use a tactic that's provided under the United States Code under Section 1782 in order to obtain this discovery. And it's got 1782 has various different restrictions on it in terms of what is allowed and how you can use that in order to get discovery for a foreign proceeding. One of the big issues that the petitioner has to do in order to qualify under 1782 is they have to be able to demonstrate that the information that they're obtaining through this proceeding under 1782, that it is asked by a person an interested person in one of those foreign proceedings, that they're seeking information from a party or a person who is in this district, meaning in this case, the District of Maryland. And one of the third things is they have to make sure that the discovery is for use in that foreign proceeding. What we have in this particular situation is we have a company, in this case, the Applees, who are seeking to obtain information not from a party that is in this district, but they're seeking to obtain information about the party that's involved in the foreign proceedings in another country, in South Africa and in the Singapore litigation. That's Nadella. Basically, what we have is a situation with the courts have been pretty clear that the person that you're seeking the information from has to be in this district. And the court doesn't just look at the identity of the person that's identified on the subpoena. You go behind that and see who's the real party in interest in this case. The real party in interest in this case, undeniably, is Nadella, which is the corporation that's involved in the South African. Nadella is not in this district. They are seeking information from GMS, which is the registered agent of Nadella. In this particular case,
counsel, just to make sure that I understand the framing, because I understand there to be two different steps. 1782 has some threshold requirements, and you've named those off. And then there's a separate set of sort of balancing factors under Intel, as I think most people refer to it. This real party and interest idea seems to show up more in the Intel analysis in the cases that I've seen from our fellow circuits, and not in this sort of first step about whether the party is in the district. That is the more formalistic requirement that the person listed on the subpoena is in the district, and that the Intel analysis is where we get to this real party and interest kind of inquiry. Is that not the right way to think about this?
That is one way. There are decisions, Your Honor, where they say that it is part of, you're looking, when you're trying to assess whether they're in the district, you are trying to assess whether they are the real party in the interest. But you are correct. There are a handful of cases, I believe we cited them in our brief, that mention the fact that it still falls under the 1782 factor as to whether they're in this district or not. And in this particular case, whether you cover it under the Intel factors or whether you cover it under the 1782 threshold matter, the reality is the discretion clearly exists that the party that's in interest here, the party that they're seeking the information from, clearly and undeniably is Nadella, which is not in this district. So whether you consider it under 1782 or whether you consider it under those Intel factors, they clearly have not rung the bell to suggest that information is appropriate in this district, or that party is certainly not in this district for which they can obtain that information.
Can I ask one other just factual clarification? There's a lot of a record here, and I had one factual question I want to make sure that I understood. There's been this recent South African decision that included a number of things, but one of them was a request for discovery from Nadella that the South Africa court denied. Did that request overlap with the information that was requested here? I know it's not exactly the same, but was there an overlap of the information requested from the South African court and the information from Nadella that was requested in this 1782 action?
I think there was, Your Honor. I think that's part of the point. Part of the issue in that recent decision was what happened was Nadella sort of reversed the idea on Applees. Applees were saying, well, you have to show that these vessels are related in some fashion in order to arrest them. And what Nadella did in that action was they filed a proceeding to say, give me discovery to support your contention that they are not related. So in that particular action, what was going on and what the court in the April 28th decision ultimately decided to do is they said, you've not produced any information, Applees, that would ultimately demonstrate that there's no relation here. You're basically going on a fishing expedition at this point in time. But the information does clearly overlap because the question that, as the court pointed out in that April decision, and we've also pointed out was available to appellees in the actions, in the South African actions, even independent of that, was the idea that the South African rules of procedure, especially in maritime jurisdictions, clearly allowed for them to ask for this information, that they could have asked Nadella for all of the information that they sought in this proceeding, and they never did so. They could have asked Nadella in South Africa for the information that was held not only by Nadella, but by any of its agents, the same as the subpoena was here. They could have ultimately gotten to the same information, looking for the motivations of Nadella in ultimately trying to arrest those vessels, and why it was that Nadella said that those two vessels were related. They did not do that. And that's the evidence is before the court at this point in time that the district court, Judge Bredar, handled. And certainly the evidence that came up to the Fourth Circuit at this point is that all of that was available to them in that foreign proceeding. And that's a critical factor under Intel and looking at the whole concept of whether they can obtain it. We're not going to allow parties to come to the United States and use the United States system in order to go after discovery that's already available on a foreign proceeding, that's already available to them over there. And they're just trying to find a way to circumvent what's already going forward on foreign soil. And in this particular case, because we've demonstrated through the record, we've demonstrated the rules of evidence, the rules of discovery that existed in South Africa, where they could have asked for information relevant to these issues that they're seeking here. There's no question that they could have done it there, and that this proceeding is all about a way to circumvent that process.
Mr. Walsh, is it your position that that a 1782 proceeding can never be used against a non-party? I mean, I thought that was the whole point of the remedial device, is to allow for discovery when it might not otherwise be available. And I don't know that necessarily the test is that it needs to be exclusively available, but there may be other sources that might have a different, aspect of the evidence that may be required. So it just strikes me that it seems you're advocating for a really narrow test when it comes to the use of this device.
Well, Your Honor, I'm not suggesting that it couldn't be used in other circumstances. In this particular case, what we have is we have the benefit of the actual subpoena that the appellees served, and that the appellees identified the information that they were seeking and what they were seeking it for. The petition identifies that they were seeking this information strictly for the South African action to determine why Nadella believed that these two vessels were related. The subpoena that was issued undeniably only asks for information about Nadella's operations, about its shareholders, its board of directors. It asks information about who the ownership of Nadella was. The subpoena itself asks about the motivations that Nadella may have had. They're not going to relevant evidence at the end of the day. What they were seeking was information sort of biting on the edges of Nadella, trying to hope that in some fashion they could get underneath Nadella's hood and try and create other havoc and create undue burden in that case. It wasn't necessarily relevant to the issues involved at all. It was all about the ownership and the structure that Nadella had.
Well, so I'll grant you that a good bit of that is that you've described it accurately, but not all of it. There's some of the documents requested and some of the deposition topics deal directly with this question of, the connection between the two ships and the like, and the relationship between the two ships and the like, and the intent or motive in arresting one or the other ships. That seems to be clearly relevant to the principal action. Now, there may be a host of other topics here that appear to be a fishing expedition, but with respect to those, are you saying that simply because the party at issue in South Africa also may have relevant information, that somehow you're cut off from inquiring whether other parties might have relevant information?
I don't believe so, Your Honor, but part of the test also is determining whether you can go after that information in the foreign proceeding first or not. We don't want to, the whole idea is to not circumvent the process that another country may already have in place. And with respect to this particular discovery, questions as to intent and motive don't have to do with the issue as to why particular vessels are related in any way or affiliated in any way. Intent and motive do not go to that issue. The only issue involved in the South African proceeding, which is not my determination, but it's what was in the petitioner's request, was that they were seeking evidence to find out why you're contending that these are related vessels. Give me the evidence to show why you believe that they're affiliated or related. Because petitioner has said that's the basis through which it seeks this information, asking about intent or motive or ownership certainly is not relevant. But I agree with you, Your Honor, there is one or two topics in there out of 24 topics and 24 document or 12 document requests that do ask, well, give me the evidence saying why you're related. But all of that evidence is complete.
I'm not following, because the point of those are all asking about Nadella's belief or motive or information. But Nadella is a party to the South African action, right? And so they're asking for GMS to provide information about Nadella's information and state of mind, instead of asking Nadella for Nadella's information. I mean, it seems odd here that they're asking a third party for information about what Nadella understood or why Nadella acted. I mean, that's the rub to me, is that they're using it is a non-party, but they're asking for party information. Isn't that the rub here?
Well, I think that it is, Your Honor. That's the problem. And part of the issue is you can't go after a third party in order to get things that you can already get in a foreign jurisdiction. The whole idea is, one of the factors in all of this is making sure you're not putting an undue burden or pressure on the third party. And in this particular case, you're asking me about something that a third party is doing, when the reality is they could have gone directly to Nadella. They had the ability to go directly to Nadella in South Africa, where all these issues are being resolved, and they chose to not do that. Instead, they chose to circumvent that process, come to the United States, and try to find a way to get that information from a third party here. And
Mr. Walsh, I'm sorry to interrupt you, but just a follow-up. So it appears that Judge Berdar seemed to understand that there was something else that may have been afoot here with respect to the scope of the discovery. And so he, as I understood his order, essentially said that to the extent that these documents are being sought to litigate in some other jurisdiction in Nevis and elsewhere, that he wouldn't allow it. But the problem with the order is that it really doesn't sufficiently make the distinction between the two actions. I was wondering if you all had gone back and sought clarification or an understanding of exactly what it was that was relevant to the South African action, because I agree in part with Judge Richardson that at least with respect to issues of intent and motive, it seems odd to ask a third party about that. But there is at least one document request, the very first one, that talks about documents demonstrating a relationship, affiliation, or connection between these two ships. And the fact that Nadella might have some of that information doesn't mean that, at least as I understand it, that another party might not also have relevant information on that topic.
Your Honor, I'll give you a two-part answer to sort of what I saw as a two-part question. The reality is Judge Berdar did not go further and say, okay, well, I've carved out the Nevis, that's not relevant, so we're just going to deal with what's relevant to the South African action. And the parties didn't do that either. In most part, the reason why the parties didn't do that was because the petition itself did that. When the petitioners filed their petition, they specifically called out what information they were looking at for the rejected contemplated Nevis action, and they identified specifically what information they wanted relevant to the South African action. So they've already self-defined and identified what they believed was relevant from that standpoint. So it was very easy to go through and say, okay, well, this is no longer relevant. The issues relevant to ownership and that type of thing are no longer relevant, at least in our perception of everything, because Nevis action was gone.
So then what are the topics that you think are still in doubt or still a matter of controversy?
Well, Your Honor, actually, I believe that everything is in controversy at this point. Most of that has to do with the fact that the April 28th ruling, the opinion of the South African court, pretty much foreclosed the idea that any of this information was relevant anymore. The appellees had an opportunity in order to identify what it was why they said there was not a relationship, and they didn't do that in that action. The court said we're not receptive to that anymore. I see my time's up. I'm happy to answer further if necessary.
I don't think so. We'll hear from you on rebuttal if you reserve some time.
Yeah.
Ms. Finley? I don't think
Yes, I was on mute. Apologize. Good afternoon, Your Honors. May it please the court. My name is Amanda Finley on behalf of the Appalese Newbrook Shipping Corporation and Falcon Conference Shipping. There are two issues in this appeal. First, whether the district court abused its discretion in granting Section 1782 relief and denying appellant GMS's motion to quash the order. The abuse of discretion standard is set forth in this court's precedent in re Naranjo. The second issue raised on appeal was the issue of service of the 1782 subpoena, which Appalese requests that this court dismiss for lack of jurisdiction pursuant to this court's ruling in Naranjo, Bury versus Bury, and Green versus Mills. As to the first issue, this court should affirm the district court's ruling for three reasons. First, the district court properly granted Section 1782 relief after reviewing all of the statutory requirements and making findings that they were satisfied in allowing Appalese to obtain evidence.
Counsel, can I go back to Judge Diaz's last question? He says that one of the things that might at least on its face be relevant are documents about the ownership structure of the ships, right? The Falcon Confidence and Falcon whatever it is, all right? But what basis in the record is there to believe that GMS would have any documents or information about the ownership of Newbrook or the various Falcon vessels? I mean, that's the very information that Newbrook has refused to provide in the South Africa action. And so what basis do we have to believe that GMS, who's not a party to the South African action, would have any such documents? I mean, in other words, why doesn't that look exactly like an unauthorized fishing expedition?
Well, in this case, the primary issue is whether Nadella improperly arrested the second vessel of Appalese. So they arrested, to give you a little bit of background, Nadella.
I understand the background. What I'm trying to get at, right, is why there are documents that why we should believe, what is the good faith basis would be another way of asking it, for believing that GMS has documents explaining the ownership structure of Newbrook and the various Falcon vessels.
It would be because GMS is jointly, we believe, upon information and belief, and we haven't got the discovery yet, so we're seeking to confirm this through the discovery, but GMS is jointly owned by the owner of Nadella. Nadella is owned by Sharma, and we believe also Sharma owns GMS. So
okay, but that doesn't answer my question, right? And I'll stop asking, and if you don't answer it, that's totally fine. But what that doesn't answer is, what is the good faith belief that GMS has documents reflecting the ownership of Newbrook and the Falcon ships, right? I mean, that's the part I'm having a hard time with. I understand you think they're related somehow, and I understand you think that Sharma is the man behind the curtain, but none of that suggests that GMS knows what seems to be a closely guarded secret about the ownership of Newbrook.
Well, the main point is we think that GMS might have information as to the intent and motive of Nadella, not of Newbrook, because that's Appalese. It's the intent and motive of Nadella for wrongfully arresting this ship for the second time.
So you agree that there's no reason to believe that GMS has documents about the ownership structure of Newbrook and the Falcon ships?
Yes, it's not about that. That would be information within Appalese possession. So we're not seeking that. We're seeking information about Nadella.
So then tell me the first document request that you made.
The first document request was all documents demonstrating a relation, affiliation, or connection between the Falcon Carrier and the Falcon Confidence. The Falcon Carrier was the initial, that's the vessel in which they're saying are associated with both of Appalese vessels as a basis to try and arrest them.
Right, but they're saying that because of some joint ownership, right? And you're saying they don't have this joint ownership.
So there's three. It gets confusing because there's three Falcon vessels. There is the Falcon Carrier, which they're trying to say both of the other Falcon vessels are related to, and we strongly dispute that they're related to. And in fact, a prior South African court already ruled that they were not related. An unarrested Appalese vessel that was, we believe, improperly arrested initially. Also, this next release, the second release or the second arrest of Appellee's vessel was also already released. And all that's pending is to determine whether there was a proper basis to determine by Nadella that this vessel should have been arrested based on it being, quote, associated with the Falcon carrier. So the ultimate, if it was as to whether there's an association between the Falcon Confidence and the Falcon, the other Falcon vessel owned by Appellee's, no, that's not the issue. It's whether they're associated with the Falcon carrier, which was Nadella's vessel. That's the issue. So they could have information regarding that. And the main thing is,
I don't understand. That's what I'm trying to get at, because all of the question, as I understand it, ultimately goes back to the father and son and whether they're fully separate or not. And I don't know whether they are or not, but I understand the argument. But the question is whether the father and son have overlapped by virtue of their business dealings or they're separate, right? But you're asking for GMS to provide documents that demonstrate whether there's an overlap or not. That's information that only you have.
We have information as to the Falcon Confidence and the Falcon Traveler. Those are Appellee's vessels. The Falcon Carrier is not Appellee's vessel. We have no information. That is information that would presumably be in the possession of Nadella, because Nadella arrested Appellee's vessels under the sole notion that the Falcon Carrier was associated to the Falcon Traveler, which was the first arrest that was set aside by the South African court, and then also the Falcon Confidence, which was the second vessel that's subject to the pending South African proceeding. So we don't have information about the Falcon Carrier, and we strongly dispute that either of our vessels are jointly owned or in any way associated with the Falcon Carrier.
And am I correct in saying the reason that you make that argument is because one of them is owned by the father, two of them are owned by the father, and one of them is owned by the son, and that's the divide?
Well, the divide, I believe, is that the Falcon Carrier was owned by, I believe it was the father, and then the two latter vessels, the ones that were improperly arrested, in our view, and the first one was already adjudicated as improperly arrested. So Nadella took the position
owned by the son, right? And so the question is, but the father and son have significant financial overlap. And so the question is whether that overlap gives them a connection or not. I mean, that doesn't seem like I understand the question. What I don't understand is what in the world GMS possibly could have to do with that question. The financial relationship between a father and son, GMS doesn't seem to have anything to do with.
My understanding is that there has been, as predicated in the prior South African proceeding, not the pending one, but the prior one in which the first vessel was released as not being related. My understanding is that the evidence showed that there was no association because there was a great divide between the father and son, and there was only one overlapping issue of ownership, and that was a joint mortgage from a long time ago, which was insufficient to show that there was actually an association between the two vessels.
And that's going to be what's litigated in South Africa in the current action. I totally understand that. What I'm trying to ask you though is why, and I don't need to answer it again because I think you've answered it to say it's not, right? But why GMS or whatever the name of the group is, GMS has any information about the father and son relationship, why the documents are at GMS.
And I apologize if I misspoke before, Your Honor. We don't think that they would have any information about why our two vessels are related, but we think they could have information regarding why the Falcon Carrier, which is the vessel Nadella arrested our vessels as being associated with, right? That's Nadella's vessel.
Right,
GMS is the registered agent.
And then I want you to go to something else, but tell me real quick, what is the good faith basis to believe that GMS would have information about the relationship between the father and son?
We don't believe that they would have information about the father and son. We believe that GMS, as the registered agent of Nadella, would have information about the Falcon Carrier and information about why Nadella chose to arrest both of these vessels. That's what we're trying to figure out. Why did Nadella choose to arrest both of Appellee's vessels? That's what we're trying to figure out. And it was based on a purported relationship between the other unrelated vessel and our vessels. And we want to know what was the subjective and objective basis for Nadella arresting these vessels. That's what we're trying to figure out through discovery. And we're permitted to seek this discovery from a witness. That's the entire point of Section 1782, is to allow witness discovery and to allow parties to obtain documents and testimony for use in a foreign proceeding through third-party witnesses. So that's what we're seeking to obtain. And we believe that the district court did not abuse its discretion in ordering that relief in this case.
Ms. Finley,
sorry, go ahead.
Can I ask a question? So, so with respect to the document request and the notice of deposition, what do the requests for documents related to the corporate governance of Nadella and related requests have to do with this dispute?
We're trying to figure out more information about Nadella so we can obtain evidence to show what might have been their motive and intent to arrest Applee's vessels. That's what we're trying to obtain. There's also a pending unclean hands defense down in the foreign proceeding. And so we're trying to determine if how to support that defense and evidence to support that defense. Because we believe that it was done with unclean hands because they arrested 2 vessels, one after already being adjudicated by a prior South African court that the vessel should have been released from arrest and was improperly arrested, not subjectively, but objectively. So,
but I thought one of the sort of the pronounced or publicly announced motives for seeking these documents was to perhaps litigate a separate action against a third party down in Nevis. Is that right?
Yes, Your Honor, that was one of the initial intentions in the initial 1782 application. The district court denied that relief, but did permit us to go forward as to the pending proceeding. And they
as to all of the requests, because that's what struck me as odd. I thought the Judge Berdard, the district court, in rejecting your ability to pursue this discovery with respect to the third party action, would have severed any requests that were relevant to that third party action. But it seems like he thought, and maybe you can clarify this to me, that the district court thought that all these documents, even if not relevant for purposes of use in Nevis, were relevant for use in the South African action. Is that how you see it?
I see it as the district court did not abuse its discretion in determining that these documents were relevant for both. Now, he denied our ability to go forward as to the contemplated action, but he said that these document requests and the deposition topics are relevant to both because they're all
interrelated. That seems like an empty order, because once you get the documents, you can use them for any and all purposes. So I don't know what that distinction means in this case.
You could use them for a different purpose, but either way, they would be objectively valid as a basis to obtain it through this section 1782 proceeding. And the court actually considered whether it should trim the discovery request based on its own ruling that the contemplated action was not a proper basis for section 1782 relief. And it decided not to. And it did not abuse its discretion in deciding not to, because it found that this would still be relevant for use in the pending foreign proceeding for which it was permitted to go forward.
Where can I find the court's analysis on that point? Where you say the district court considered trimming and chose not to because it found that it was relevant to both.
Yes, Your Honor. I will cite you to the district court's order at page 14, in which the district court found GMS actually conceded in its motion, but I'll cite the exact quote for Your Honors. GMS acknowledges in its motion that the documents relate to the South African action and does not otherwise explain why such requests are unduly intrusive or burdensome. That is the order at page 14, citing to GMS's own discovery motion at page 18. So actually, GMS somewhat conceded this issue below in its motion, and we would argue did not properly preserve the issue for appeal based on that. This is what the district court found, and it cannot be viewed as an abuse of discretion in this case based on the facts and circumstances. All of these documents could be used and will be used in the foreign pending proceeding when we're finally able to get them. That's our intent, is to show that Nadella wrongfully arrested this second vessel, yet another unassociated vessel with the Falcon carrier.
Can you address the point that, at least in significant part, these are all requests for information about Nadella? So Nadella's intent, Nadella's actions, Nadella's structure, Nadella's this. And Nadella is the party in South Africa. And we typically think of 1782 as for non-party discovery. So if you want party discovery, you get it in the actual litigation. And so you are entitled under South Africa law to make requests of information from Nadella. And you did or didn't do it or whatever, but that's up to South Africa. But courts have been really hesitant, it seems rightfully to me, to allow you to come to here to a third party and request not evidence from the third party, but evidence about the party that's at issue in South Africa. But why shouldn't that be a concern for us here?
So Your Honor correctly pointed out that this exact issue is dealt with in the discretionary factors and not the initial required statutory factors. So initially, this goes to a discretionary issue, and again, the abuse of discretion that we say did not exist here in this case.
Well,
so
not necessarily, right? Because the question is whether the party is in the district. And if I read your requests, the requests all say Nadella's this, Nadella's that, Nadella's the other thing. And Nadella's not in this district, right? So, I mean, I think it could well fall under the first four factors that are mandatory. I get some courts have treated it under Intel, but when you request Nadella's information, Nadella's not in this district.
But we are permitted to seek, applicants under Section 1782 are permitted to seek witness discovery. That's the entire point of the congressional statute. The congressional intent of the statute is for witness discovery to be obtained, and we can obtain it about a party in a foreign litigation. That's the whole point, is that you want evidence and information about a party in a foreign litigation. And that's supported by Kyobel versus Sam Calden versus Cravath, Swain and Moore. That's a Second Circuit case in which they declined to consider the principal agent relationship or whether documents held by a subpoenaed party belong to a foreign party. It's also supported by Meese versus Buter, which is Second Circuit, explaining that the court should not read into Section 1782 requirements that are not rooted in the text. So we are permitted to seek information about Nadella, but we are seeking it undisputedly from GMS, who is, again, conceded to be located in the district. So that statutory requirement is satisfied. And as far as the discretionary factor about whether we're seeking it from a party, we are not seeking information from a party. We're seeking information about a party, which is what typically happens in Section 1782 proceedings. You want to seek information about a party so you can bolster claims and or defenses in that action. And that's what we're seeking to do here. Now, GMS cites Schmitz versus Bernstein, Leibhardt versus Lipschitz, Second Circuit case, in which the Second Circuit affirmed the district court because it did not abuse its discretion based on the facts. And they try to bolster their argument on this exact issue using that case. But importantly, in that case, the German Ministry of Justice and the prosecutor specifically requested that 1782 relief be denied. So it showed that the foreign court was not receptive to judicial assistance. So that was the real reason that was denied. And again, the primary ruling in that case was affirming the district court and determining that it did not abuse its discretion, which we believe should be done here as well. There is no reason for the court to go beyond the subpoena to see who we're seeking the information from. To the extent they don't have the information, if that's what it is, they can obviously respond to the discovery and say, we don't have the information. But now it seems that they're just trying to forestall even responding to the discovery. And this is discovery that was properly issued by the court, and there was no abuse of discretion in doing so.
Can you talk just for a second about the merits of the service of process issue? I understand that you want to claim it's an interlocutory order that somehow doesn't get wrapped up in the final decision here to order discovery. But can you tell me just a minute what your argument is on how this is personal service on GMS? And I assume you're not alleging that you have actually served Mr. Shawarma.
No, we are not. Correct, Your Honor. We have not yet served.
Just make sure I understand. I just want to make sure I understand your argument with respect to the personal service of GMS.
In regards to the personal service of GNS, first, we believe that this issue should be dismissed from this appeal for lack of jurisdiction. That's held in numerous case law from this court, including Naranjo, Bury versus Bury, Green versus Mills, specifically finding that an issue of improper service is not a final or otherwise appealable order.
Okay, well, we think it is, so go forward.
Okay, Your Honor.
That's why I said go to the merits.
Okay. Alternatively, appellees request that the court affirm the district court because it did not grossly abuse its discretion, resulting in fundamental unfairness. That's the standard that's cited by GMS, and it's citing from the Eighth Circuit's precedent because there's no precedent from this court on this issue. But we think that it is clear that there was no abuse of discretion resulting in fundamental unfairness.
But the question is whether personal, I mean, it strikes me the question is whether personal service is required. The statute, one might think, or at least I might think, requires personal service. And so if it requires personal service and that wasn't done, then the standard doesn't matter a whole lot. So why do you think there was personal service done? That's maybe get away from the jurisdictional and standard review. Tell me why, again, on the merits, you think personal service happened.
First, we would contend that personal service is not required of a subpoena under Rule 45. Most of the courts in the Fourth Circuit have held that personal service of a subpoena is not required. There's a majority view and there's a minority view in this regard. And the majority of courts in the Fourth Circuit have held that, Your Honor, I see my time has expired. May I have leave to?
Yeah, but we understand that argument. Maybe go to your next.
Yes,
I'm good. I tried the best I could.
Oh, yeah, no, I want to continue to answer. I just wanted to ask for leave because I saw my time was expired. So in the event that the court determines that personal service is required, we had a process server, Applebee's had a process server that served GMS at its office location in Maryland on the third attempt of service. He handed the subpoena to the employee of GMS at its office via process server service. So that should be deemed personal service in this case. And the district court went through a very in-depth analysis about why a service was appropriate in this case. And we believe that there was no gross abuse of discretion in this regard, Your Honor. Do you have any further questions for me?
I don't think we do. Thank you very much.
Okay, thank you.
Counsel, do you have any rebuttal? Sorry, do we have further questions? No, I don't think so. Counsel, do you have rebuttal?
Very briefly, Your Honor. Basically, I just want to address two or three different things that
they all say that.
I'm going to try to do my best. Two or three things that were identified. When you go back and look at the petition in this particular case and the reasons why the petitioners, the appellees in this case, were seeking this information, it was for two reasons and two very distinct, separate reasons. They were looking for the Nevis contemplated action that Judge Bredar rightfully rejected, was so they could pursue their wrongful arrest argument. So they could pursue some idea that they could go after other parties potentially responsible in a wrongful arrest. That's the contemplated action. Judge Bredar rejected it. It is rejected. That's all of the evidence relevant to a wrongful arrest. What the petitioner said is the other reason why they wanted this information was relevant to the South African action. And in the South African action, the issues were whether there is a relationship between these vessels. And that's the issue that was involved. It wasn't an issue relative to wrongful arrest. I completely understand that at the end of the day, the appellees in this case were seeking as much information as they could about Nadella and all its associated parties and ownerships so that they could pursue a wrongful arrest. Unfortunately, wrongful arrest is no longer at play in this particular circumstances because that was rejected. Once that was rejected, and if you look at the petition that talks about the South African action and why they need it, and it's clear in the petition, they're seeking that information to understand what the relationship is between these different vessels. It's very clear what's going on. The other thing that I want to make sure that the court notes in the April 28th, 2021 decision that we believe the court should take judicial notice of, that court expressly rejected the notion that there was this concept of a wrongful arrest. South Africa is a little different than United States law. They refer to it as dirty hands, which is sort of the equivalent of the unclean hands concept and whether there's a wrongful arrest. And in that decision in April 28th, paragraph 53, the court actually specifically said that the evidence, the ability to expand and get this additional discovery that they're looking for to try and demonstrate somehow that they should have additional time or additional rights to answer why they say there's no affiliation between these two vessels. The court said it may very well have simply been a misguided attempt to obtain evidence in order to bolster the respondents, in that case, the appellees, be the same as the appellees, reliance on the quote, dirty hands argument. The court in South Africa rejected the very evidence that they're asking to get in this case now. It rejected the concept that there was a wrongful arrest. It rejected the concept that there was no affiliation at this point in time between these vessels. And in light of that, there should be no basis under 1782, whether it's under the actual statute itself, or whether it's under those discretionary factors, why in fact this particular subpoena should be enforced and go forward. I completely appreciate the fact that Judge Bredar did not have that April decision at the time of his ruling. We have it now, and it's something that certainly we can't ignore in the process. With no other questions.
Can I ask Mr. Walsh, I'm sorry, I want to ask a question. So you don't, I want to make sure I get this right, is when Judge Bredar made the distinction between the South African action and the Nevis action, you don't have any question that he intentionally decided that irrespective of that distinction, that the entire swath of documents and the topics that were proposed in the deposition were, in his mind, still relevant to the South African action. That was his ruling. You agree with that?
I do agree that was his ruling, but I don't believe that he made the distinction. Fundamentally, Your Honor, I obviously disagree with Judge Bredar's decision, which is why we're here. I don't believe that they were even related from that standpoint. But I also agree he did not make a distinction. He did not examine or explain in any way, and neither did petitioner, as to why those additional information about Nadella was relevant to the issues in the South African action. He did not make that distinction.
Thank you.
With that, I have nothing further. Thank you.
Thank you very much. We appreciate your arguments, and we'll go directly to our next case, which is number 20.
Judge Motz, could we take a short break? Sorry.
We'll take a short Good afternoon. We're happy to hear from you now. And we'll hear argument in our tax case, McLean versus Commissioner of Internal Revenue. Can people hear me? Yes? Yes? Okay.
Yes.
Thank you. Mr. Lader?
Yes, good afternoon. May it please the court. My name is Daniel Lader on behalf of appellant Brian McLean. And the relevant background facts of this case are more or less straightforward. This case arrived in the tax court pursuant to a notice of determination in a CDP collection due process hearing. However, appellant, and this point is not disputed, fell into the rare category of individuals who had not had a prior opportunity to dispute the asserted tax by the IRS. What happened was the appellant self-reported his tax liability for 2008 of approximately $2,000. The IRS subsequently audited the appellant and made adjustments asserting he owed approximately $20,000 in excess of what he reported. However, when the IRS issued the notice of deficiency, it was attempted to be delivered one time and returned to sender, never actually having made it to appellant Brian McLean. So therefore, because mailing of the notice of deficiency is legally effective to allow the IRS to make an assessment, which is a recording of liability owed, that process occurred without the appellant ever being able to go to tax court and directly challenging the alleged deficiency in a prepayment forum. However, because of the CDP...
So Mr. Lader, can I ask you about that? So what's the legal significance of that with respect to the initial overpayment by your client? Are you saying that had he had that notice, he then could have, I guess there's two different, he could have or would have not only challenged the deficiency, but at that point the light bulb would have gone off and he would have realized that he had overpaid the IRS?
Well, Your Honor, what happens is as soon as a taxpayer does challenge a notice of deficiency and goes to tax court, properly, timely filing a petition, Section 6512 says that the mailing of the notice of deficiency kickstarts the refund process and is treated as an imputed refund claim. And it specifically says in a parenthetical whether or not the refund claim was actually filed. And this is a well-crafted scheme within the code that essentially balances the playing field, because the IRS at this point has to decide if we're going to assert this alleged extra amount owed, this is going to open the entire year. And it necessarily has to, because as we all know, taxes can be very complicated, involving, multiple different areas of income. Sometimes losses can be used to offset other gains, but sometimes they can't, depending on character. So it's not just
just so I understand that, I think I do, is that you're saying at that point the whole thing would have been open and your client could have challenged the entire liability. But I guess my question is, maybe we have no way of knowing this, would he have? Because it doesn't appear that he understood that he had overpaid the IRS.
Yeah, that's correct, Your Honor. And oftentimes that's the case, and that's even a tax court quote in a 2004 case, Montgomery, where the court considered whether in a CDP proceeding similar to here, where the underlying liability was properly issued, whether the underlying liability included amounts self-reported by taxpayers. And the tax court specifically stated that with the complexity of the Internal Revenue laws, that is often the case. The taxpayers do not know a mistake was made until, whether by their own accord or external forces, they're forced to re-examine the year as a whole. That's exactly what happened here. And yes, if the notice of deficiency was received by the appellant, of course you have to assume that he would timely have a petition to the tax court, but that's an easy assumption to make given that you have 90 days from that time period, and the appellant timely petitioned within 30 days of receiving the notice of lien in this case.
Would that have been within the statute of limitations to seek a refund?
So it is actually a two-step analysis. Number one, you have to, like we were just talking about, because the taxable period liability is made of all these different factors, not any one thing in isolation, you first have to look as a whole and determine the overall tax liability. And then step 2 is to determine how much of that, if any or of all, is still within the refund limitations period. But you have to do step 1 first. You have to first examine and determine the accurate tax liability for the period. And then if there are payments that are outside the statute of limitations, you're limited in how much you can get a refund for. If not, you may be able to recover the entire amounts paid, the entire refund.
Well, the reason I asked that, Mr. Lader, is because one of the, I think the tax court opinion in this case suggests that there's a really substantial statute of limitations problem with this whole basis for seeking a refund. And I just want to know what your response is to that. Even under the best case scenario, as you have described it, would this claim for a refund have been within the statute of limitations?
Yes, Your Honor, and that's actually explicitly conceded by the IRS in their answering brief. They dispute that there's jurisdiction at all, but assuming there's jurisdiction and understanding that mailing of the notice of deficiency equates to that imputed refund claim, the IRS pointed out that appellant filed his tax return on October 15th of 2009 pursuant to a valid extension, and his payments were made as late as, or excuse me, the notice of deficiency was mailed on August 7th of 2012. So the refund period of limitations is either 3 years from the time the return is filed or 2 years from when the taxes are paid, whichever is later. So because he filed on October 15th, 2009, he had 3 years until October 15th, 2012 to request a refund for all the payments. And because the notice of deficiency was in August of 2012, that imputed refund claim was timely for all the payments, and would be entitled to a full refund for all amounts paid. That tax.
All right. Thank you.
Can you help me understand when I'm reading the statute, and I assume what you're trying to put your theory under is this underlying tax liability language. Help me understand how I think of underlying tax liability to refer to what you claim it to be. I'm just having a really hard time as a textual matter understanding how the underlying tax liability can instead be the total, tax refund. I mean, they don't seem to match up to me. What am I missing?
So, Your Honor, that is definitely the threshold starting point for this analysis. And you have to understand that, and this court has explicitly acknowledged in Imes, in the 2017 case, that Congress envisioned only limited CDP review of a taxpayer's underlying liability. And that is because typically when you get into a CDP hearing, all the taxes are duly and properly owed. And to the extent that they were disputed, that means the taxpayer had a prior chance to dispute it. So CDP hearings are primarily to say, this is going to be too economically unfeasible for me. I would have to sell my house. I wouldn't have to be able to do any of this. I need to propose a collection alternative. However, the safety net was installed for taxpayers like Mr. McLean, who never had a chance to challenge the amounts because he never received it. And so the reason
but the question, I understand all that, but what I'm getting at is you want to sort of use the word amounts, right? You want to use the abstract phrase instead of underlying tax liability when the CDP hearing is about a particular underlying tax liability, not some total everything under the sun, but a very specific underlying tax liability, no?
Correct. The underlying tax liability of the taxable period. That is what the statute actually says. The person may also raise at the hearing challenges to the existence or amount of the underlying tax liability for any tax period. It does not say the underlying tax liability giving rise to the lien or levy. It doesn't say the asserted deficiency. It's the underlying tax liability for the tax period. In this case, the tax period is 2008. That necessarily has to encompass the entire year's tax liability, because you can't make adjustment X over here and pretend that it can never affect adjustment Y. All these different items of income and deductions and credits and exemptions have to work together. So when you make an adjustment on one side, it may have a statutory adjustment that comes with it, more Medicare tax, more less entitlement to a credit. You cannot bifurcate it or break it into even more buckets. It just would be an unworkable system that would not be in accord with the code as a whole. It's really, as difficult as it is to calculate the ultimate tax liability when you are looking at it together, it's impossible if you try to split it apart. They're not in isolation. And that's why once the liability issue is properly before first IRS appeals and then the tax court, you must, step one, determine the correct tax liability for the entire period. So with that in mind, then if you move to the section that allows an imputed refund claim, which is section 6512, and it's under B1 and B3. First, under B1, it provides jurisdiction.
Mr. Leader, I'm sorry to cut you off, and I'm sorry to keep harping about the statute of limitations, but I think you adequately answered the earlier question I had about how if you had the notice of deficiency, that the statute would have been told once the case had started there. But of course, you didn't have the notice of deficiency, and you're now in CDP land. And the question is, hasn't the statute of limitations to seek a refund by that time run?
Your Honor, that's why I stress it's the mailing of the notice of deficiency that imputes a refund claim, not the receipt. Receipt has legal significance in other contexts, but in this case, it's a mailing. And so just as the mailing allowed the IRS to, once the time to petition the tax court expired, assess the tax liability, it also imputed the refund claim, which meant that all of his refunds in this case were timely under that. And if you go to 6512, which is the imputed refund section, it speaks, 6512B1 speaks giving the tax court jurisdiction to determine if the tax court determines there's no deficiency and that the taxpayer has made an overpayment, jurisdiction to order a refund. And the only requisite is that the taxable year to which the petition relates is the year that's open to tax court at issue. And section B3, B3B specifically cross-references the look-back rules of 6511, and that's where you find the parenthetical whether or not filed, which, as we all can see, it doesn't matter whether he actually filed an administrative claim for refund. I see my time's expiring. Thank you very much.
I think it's expired. Thank you very much. We'll hear from the government. Ms. Erickson? Your speaker's not on.
I knew I was going to forget that.
That's all right.
May it please the court, Marian Erickson for the commissioner. As I know you all understand, this is an appeal from a collection due process hearing. When Congress enacted this statute, the purpose was to allow taxpayers one more chance, one last chance to persuade the IRS not to take some collection activity. Taxpayers have a lot of chances to talk to the IRS about their liability before you get to this stage, but Congress felt it was important for them to have one last chance. So these procedures were enacted whereby if you receive a notice that the service has filed a lien against you or that they're contemplating a levy, you can request this special kind of hearing with the independent IRS Office of Appeals. Now, in the course of the hearing, by statute, taxpayers are allowed to raise, as my opposing counsel has noted, any issue relevant to the tax liability or to the collection proceeding. For example, they could suggest that a less intrusive collection proceeding would be more appropriate, or they could raise a spousal defense or make an offer of a installment agreement or a collection alternative like that. The other thing is, if the taxpayer has not had a previous opportunity to dispute the existence or the amount of the tax they owe, either in a deficiency proceeding or in another proceeding administratively before the IRS, then they're allowed to raise that as a defense to the collection action. In other words, they will say, well, you shouldn't take this collection action because I don't actually owe this amount of tax, or I don't owe you any tax. And if the taxpayer can persuade the appeals office that that is true in the course of the CDP hearing, then the appeals officer will say, okay, you're right. We're not gonna go forward with this collection action, and that's the end of it. And that could have happened here if only Mr. McLean had his records in order and had presented them to the appeals officer, either in the first CDP hearing or the supplemental CDP hearing that the tax court remanded because the tax court felt that Mr. McLean was given another opportunity to present his evidence, which was—
Ms. Erickson, sorry to interrupt you, but you say that could have happened at the CDP level, just so I understand it, but even there, the petitioner in this case, Mr. McLean, could not have then sought a refund of monies paid, or could he have sought a refund for monies paid?
Well, he could have requested that the appeals office take into account his documentation showing that he no longer had a tax liability. My understanding is that in that setting, the appeals officers are not obligated to process a refund claim. They would have advised him to file a refund claim at that point. And depending on the timing, it may or may not have been timely with respect to certain payments he had made. It just depends on the timing. As we laid out in our brief, he made payments over time of about $1,700. And I think the latest date would have been January 21st of 2014. That's the latest date that he would have been able to make a claim for refund.
So just so I understand what you're saying, so he could put on whatever evidence he wanted to, but the CDP hearing is only, do you have a liability and what is that liability? And that's it. That's the only authority that they have. That's the underlying tax liability point. What you're saying is, independent of the CDP hearing, depending on timing and lots of other things, he might be able to seek a refund, but that's not part of the CDP hearing, and that's not part of this 6330C that we're talking about.
Yes, exactly, Your Honor. Well, the CDP hearing exists only for one purpose, and that is to decide whether or not to proceed with the collection action. And that's equally true when it goes to the tax court on appeal. The tax court only has jurisdiction to decide, did the collection officer or the settlement officer in the appeals office, did he correctly decide to proceed with this collection action? And once that's been decided, and once the IRS acknowledges you don't have a liability, we are not going to pursue a collection action, then the case is moot and it should be dismissed. And I think that many courts have held this. The tax court in the Green Thapedi case is really the seminal case in the tax court. Several courts of appeals have agreed. The Second Circuit in the Roosh case, and then the DC Circuit has two cases, the Byers and the Wilson case, that confirm this, that there's simply no jurisdiction, that it's moot once there's no liability and no collection action proposed.
Had the notice of deficiency actually been, well, I guess it was mailed. I guess there's some question about whether or not it was received, or maybe there isn't anymore, but had it been received and had Mr. McLean proceeded under the notice of deficiency before the IRS, he could have then brought into that proceeding an argument that he had overpaid. Is that right?
Yes, that's correct, Your Honor. In a deficiency proceeding, which is what it is under 6512, when a taxpayer receives a notice of deficiency and timely petitions the tax court, then the tax court does have jurisdiction to determine an overpayment and to order a refund. And that is specifically laid out in the statutory scheme. In a deficiency proceeding, in an interest abatement proceeding, or in a proceeding to determine innocent spouse. those are the three situations where the tax court explicitly has jurisdiction to determine an overpayment.
Right. Well, Mr. Lader's argument is that he was deprived of that opportunity in this case, and so this is the next best thing.
Well, not every taxpayer gets to have a prepayment forum. That statute specifically says, as he acknowledged, that as long as the notice of deficiency is properly mailed to the taxpayer's last known address, which it was in this case, the IRS can proceed with assessment. And it's unfortunate, but it would, I believe that Congress decided it would be too big of a burden to make the IRS prove that it had been received in every case. Now, in the case, however, of a CDP hearing, we do have to prove that we sent it, and they do have different levels of requirements for other situations. But I understand that it seems unfair that some taxpayers have prepayment forum and others don't. But this is the way Congress has laid out the statute. And if you look at the history of the tax court's jurisdiction to order a refund or even to determine an overpayment, the Board of Tax Appeals didn't even have that jurisdiction when it was first enacted. And then even a few years later, when the Congress gave the tax court jurisdiction to determine an overpayment, they still didn't have jurisdiction to order a refund be paid, not until I believe it was about 1988 when they finally got that jurisdiction. And I also want to point out that all three of the situations in which the tax court explicitly has jurisdiction to determine an overpayment, those situations are also explicitly made connected to the statutes of limitations on refunds. So unless these claims are timely made within the 6511, 7422 statute of limitations on refund claims, they cannot be considered by the tax court either.
So what about the argument that, tax liability and just in the abstract connotes not just a portion of the liability, but the entire amount that was collected by the IRS, whether early on as a result of the taxpayer's filing of his return or later, in this case, by virtue of this lien and levy process? Why isn't that right? That in order to calculate tax liability, you've got to begin and end with the entire liability.
Well, if I understand your question correctly, I think the answer is that in a CDP hearing, the purpose is not to calculate exactly how much you owe or don't owe. First of all, liability means something that you, the taxpayer, owe. And so if you've overpaid, you do not have a liability. And that's exactly what the CDP proceeding is designed to do, determine whether or not you have a tax liability. And if you do, whether or not the service should proceed to collect it in the manner they have proposed to collect it. If you don't have a liability, that's the end of the story in a CDP hearing. It's a very limited jurisdiction for a limited purpose. It's not, as the taxpayer here posits, an opportunity to insert a deficiency proceeding into the tax court when, in this instance, for example, the taxpayer never even made the argument that he was entitled to a refund in the CDP hearings. So the tax court's jurisprudence in this situation is only to review what the Office of Appeals did. And if the Office of Appeals didn't even consider a refund claim, how could the tax court rule on that?
That sounds like a waiver argument. Did you make a waiver argument in your brief?
I don't think we explicitly did, no. If the court has no further questions, I'd just like to say that I believe the taxpayer here fundamentally misapprehends the purpose and the statutory structure of the CDP scheme. The Congress enacted this legislation for a limited purpose, only to determine whether or not a collection action should proceed. Congress did not intend that you could simply turn it into a deficiency proceeding just because the taxpayer did not receive a notice of deficiency. That was not Congress's intent. That is not what the statute says. And no court has ever held in taxpayers' favor on this issue. So we would respectfully request that the court affirm the decision of the tax court. Thank you.
Thank you very much. Mr. Lader, you have rebuttal?
Thank you, Your Honors. I believe the government completely is ignoring the applicable statutory provision. And yes, CDP hearings are primarily to determine whether a collection action can move forward, but their position fundamentally ignores section C2B about the underlying liability. That is a separate consideration. So when she says that the case would be moot if the IRS determined not to move forward with a collection action, that only applies when subsection C2B, allowing a taxpayer to challenge the underlying liability, is not operative. Because the underlying liability was properly before the Court of Appeals.
I'm sorry. I just want to make sure I understand what you're saying. She just said she's not ignoring it. She reads the words underlying tax liability to refer to underlying tax liability and not the total tax refund or liability. Right? I mean, I guess I'm just having a hard, I want to make sure that, I mean, you have an argument to the contrary, but to suggest that she's ignoring the words, I mean, she just reads the words to mean something different than you do.
Your Honor, I would argue that the government is superimposing a statutory language that's not there, that says that the only purpose of a CDP hearing is to determine whether collection can proceed. And when you read underlying liability provision, that does not directly say if the IRS concedes there's no additional underlying liability such that there's no levy, then there's no case or controversy to take to court. That requirement is not imposed, and that is why I say they're ignoring this provision on its own. They're superimposing statutory language that only allows underlying liability in the context of a collection action, and that is just not what the statute says. And although we contend that the statutory language is clear, to the extent you need to look at congressional intent, it's even more clear that taxpayers were inadvertently missing out on the prepayment form to challenge the entire open year when the IRS makes an adjustment. And Congress very carefully crafted this safety net within the framework of a CDP collection due process hearing in very limited circumstances that everyone agrees apply here. Liability is an issue as well. Liability concerns assessments. Liability concerns assessment because assessment is a recording of something that you owe.
Are there other examples that you point to me in the Internal Revenue Code where the term liability refers to a refund?
In the code, I cannot off the top of my head. I'd be happy if I come.
No, that's I thought maybe you might have an example where it might be. That's fine.
No, however, I can point out that just a few months ago, the Seventh Circuit had a case, Jeffers, and in Jeffers, the salient difference was that Jeffers absolutely had a prior chance to dispute the liability, and so this provision did not come into play. So Jeffers made the creative argument that a refund is an alternative collection action. And while this precise issue wasn't before the Seventh Circuit, the court said, and I quote, refunds concern underlying liability. They rejected the idea that a refund was a collection action and specifically said it's an underlying liability. So while that issue wasn't before the court, to me, it's common sense. Congress enacted procedures to catch taxpayers that would fall through the cracks and lose out on the opportunity to fully and correctly determine the taxable period liability once the IRS made an adjustment. And so that's what this court said when it said Congress.
Mr. Lader, can I ask about that when you say they lose the opportunity, but even without the notice of deficiency, which admittedly in this case wasn't received, that doesn't mean that the taxpayer can't on his or her own still challenge an overpayment, right? Once they become aware of it, it just seems in this case, based on this record evidence, that your client, for whatever reason, just didn't know until he got to the CDP hearing that he had overpaid.
That's correct, Your Honor, and that is just the risk that the IRS takes when it says, when the IRS issues a notice of deficiency, the notice in the part of the due process idea of notice and opportunity to be heard is not that the only possibility is that you owe this $1 more or $1 more $1 million. The notice is that your taxable period is being reopened, and we're going to say you owe a lot more. And the counterbalance to that is the taxpayer gets to say, hey, not only do I not owe more, I actually overstated what I owed. I owe less. And so that you can't have an arbitrage like scenario. And the taxpayer bill of rights really, you know, whether they're independently enforceable, they really speak to these points of finality, of fairness, of paying the correct amount of tax. And these are provisions in the CDP context that are very clearly designed to prevent the inadvertent, because as we all know, Mr. McLean did not refuse delivery. And there's case law out there saying you can't refuse or evade delivery and then be able to challenge your liability in a CDP context. So this is really designed as remedial legislation to prevent the types of unfairness that are applying here. And to say, well, if there's nothing that you did wrong, you did everything right. Once you finally got the notice actually received, you should be in the same shoes as had you received an NOD. And that is exactly the outcome that we're advocating for. And the IRS is trying to advocate, opposing counsel, Ms. Erickson even said that it would be unfair. And our point of view is that Congress remedied that. And the statutory provisions clearly understand that if you don't receive an NOD, the IRS still has to give you the right to go to a CDP before they can take your property and take your money. And that's why these limited subset of taxpayers like Mr. McLean have the opportunity to challenge the underlying liability there.
All right. Unless we have, I don't think we have further questions. Thank you very much for your argument.
Thank you very much, Your Honors.
We'll take the case on.
I would just like to request that the court reverse the tax court's opinion below and remand with instructions for a refund.
Perez. Ms. Johnson? Yeah. Mr. John.
Good afternoon, Your Honors. This case came about due to a traffic stop in 2018 in Union, North Carolina. The central issue in this case is whether or not the police conduct violated my client's constitutional rights. That would be the appellant. Your Honors, this case began once an Officer Marcel from the Monroe Police Department stopped the appellant's vehicle in Union County. And when he stopped the car, he purportedly stopped it due to a fictitious tag. We had a suppression hearing in this case where the main officers testified, and that testimony is pertinent to what really transpired. It really helped us fill in the gaps. And I think this case is very fact specific. And if you look at the facts, Detective Furr is one of the officers involved, Detective Hagler is another, and then you have Officer Marcel. These are the three main officers involved. And I'm going to use these three names in conjunction with explaining why we feel that my client's constitutional rights were violated. Specifically, Detective Furr, who was not present at the scene initially, called before the traffic stop occurred, called for a backup or a canine to arrive at the scene. So what we have in Detective Furr's testimony, if the courts will review the transcript, is that Detective Furr already determined that he was going to stop the car and also already called a canine unit. When Officer Marcel stopped the car, he was asked during testimony why he would stop the car, who informed him to stop the car. And he said that he received a call from Vice Narcotics, specifically Detective Hagler, to stop the vehicle. And then once he stops the vehicle, what was really incredible at the hearing, and I don't know if Your Honors had a chance to take a look at the transcript, but what happened was Officer Marcel prepared a report where he indicated that it was he who stopped the car and approached the driver's side and requested the driving credentials, including the driver's license. But what actually happened once we showed the video is that he never approached the driver's side, nor did he ask for any driving credentials or registration. He actually sat at the rear. This is critical because in the beginning of the suppression hearing, the government's counsel acknowledged that the sole basis for the stop was the fictitious tags, the purported fictitious tags, and not anything dealing with a drug investigation or any suspicion of drug activity. So the sole purpose for the stop as we have it are fictitious tags. And so Officer Marcel, who's supposed to investigate the primary purpose of the stop, even if the court would consider this a Wren stop, even though the government didn't proffer that, even in that context, you have a responsibility as an underlying investigative officer to not abandon the primary purpose for the stop. And in this case, by not engaging the officer, we would argue that Officer Marcel initially abandoned the purpose of the stop. It wasn't until 4 minutes into the stop that Detective Hagler approached Officer Marcel with the license. And just to be clear, Detective Hagler is the detective that approaches the driver's side. So the way it works, Officer Marcel stops the car. He gets out, he goes to the rear of the vehicle. Almost immediately, Detective Hagler is there on the scene and he approaches the driver's side. Detective Hagler in his testimony said some incredible things. He said that once he engaged the officer, he could not recall if he questioned the officer regarding the registration or the license plate. He did acknowledge that he obtained the driver's license. He then said he took the driver's license. He did not give it to Officer Marcel immediately. He took the driver's license back to his car where he can conduct a background check. When questioned further, he said he did not have a laptop in his car and that he had to call headquarters. When questioned further what information he got from headquarters, he said that he could not recall. So what happened here at this point, Detective Hagler takes the driver's license and gives it to Officer Marcel. And as he does so, he tells him, you can hear it on video that we did submit to the court, the canines are on the way. And what we contend is that this is part of the engineering of a prolonged detention to allow the canine unit to arrive. We are already 4 or 5 minutes into the stop, and we are just beginning to look at the driver's license, because at this point, Officer Marcel takes the driver's license to his vehicle, and then he begins to look at the database. What's more telling is that during the next several minutes, Detective Hagler and other officers engage Officer Marcel while he's in his car and ask, do you need anything else? Do you need anything else to help you with this investigation? He repeatedly says no. And he was questioned about this at the suppression hearing and under cross-examination. And when asked why he did not ask or request all the items simultaneously, he said that he wanted to conduct an investigation. He wanted to do it his way. And when questioned further, he said the line that he's not a multitasker. He needed to do, he couldn't receive the information, specifically the VIN number, while at the same time looking into the computer database. What we find, if you look at the timeline, about 7 minutes and 46 seconds into this stop, Officer Marcel determines that the driver has a revoked license. We go on for several more minutes, going into the 13th minute before the VIN number is even provided, which was the primary purpose of the stop. And then once that's investigated, it's determined that the car is properly registered, that there is a license plate actually belonging to the car, to an actual owner, and that license plate was valid until August of 2018, which was after the incident occurred. So what the gist of our argument was, if you look at the number of case law, beginning with Rodriguez versus United States and its progeny, especially here in the Fourth Circuit, what you see is an impermissibly prolonged detention to allow canines to arrive is unconstitutional, so long as the primary purpose is not fulfilled or unreasonably delayed. We contend that the investigation into the tags, that investigation was unreasonably delayed, given the fact that it didn't even begin until many minutes after the stop occurred. Your Honors, I would point out that in many of the cases in the Fourth Circuit dealing with this very specific issue, prolonged detention, courts have said that independent basis can arise that would allow for a prolonged detention under reasonable suspicion, such as knowledge of ongoing drug activity, such as furtive movements, such as the odor of marijuana or narcotics. Your Honors, in this case, the record is clear. There were no observations of furtive movements, nervousness, danger or fear of being harmed. In fact, there was nothing in the record whatsoever as it pertained to any independent basis for reasonable suspicion.
Mr. Johnson, could I ask, is it your argument that at the 4-minute mark that was too long? I mean, how long was too long in this case? Because by the time the canine came and it sniffed the car, I think there were maybe 17 or 18 minutes into the stop, which in the abstract doesn't seem like a long time compared to other stops. So is there a particular line of demarcation that you say was unreasonable, or is it just the entirety of the stop?
I think it's the entirety of the stop. But to go back to the 4-minute mark, imagine being stopped by a police officer and not being asked immediately to provide your driver's license registration. Even the trial judge remarked that it is commonplace that when a stop happens, a traffic stop specifically, that the police officer or investigating officer would request a copy of the driver's license and registration. In this case, when you go back to the beginning, Your Honor, we talk about the purpose of the stop, which is the tag. That was the purpose of the stop. So after 4 minutes passed and no activity, positive activity indicating that there was an ongoing investigation into the tag.
I'm sorry. Can I just make sure and I confess, I may have my facts wrong, but I thought that Hagler had the driver's license before the 4-minute mark.
He did, and if I may respond, Your Honor, he had a license before the 4-minute mark, and he was questioned on cross-examination. He took the license to his vehicle, which did not have a computer inside. He said at that point he called headquarters. We questioned him about that. What did you learn from headquarters? What did you ask about? And his response on the cross-examination.
So you agree that by the 4-minute mark, they had gotten the driver's license from your client?
Absolutely, but they did anything.
Okay. I'm sorry, I just misunderstood you. My confusion. I thought you were saying they didn't get it until later. I'm sorry. Go ahead.
What I was indicating, Your Honor, respectfully, was that the investigation didn't begin until the 4-minute mark. Yes, they did. Detective Hagler did get the license, but he didn't do anything with it. Nothing.
Well, I thought you said he called headquarters.
He did, Your Honor. That's what he indicated, and I would say respectfully, a careful review of his testimony would show many inconsistencies. This is what he said. He said he called, but he could not remember what he was told. And this is at the hearing. He had no notes, no knowledge whatsoever that can contribute to any investigation as to the license plate or the vehicle. So then, as he comes back, interestingly enough, Your Honors,
I just want to make sure. So I thought Hagler, and I don't have the testimony in front of me, but I thought Hagler said that he learned from headquarters that the license was not valid.
It was inconsistent, Your Honor. If you read his testimony, he was all over the place, quite frankly.
Did he say at J127, I learned the license was not valid?
Judge, I don't recall him saying that, and reading the testimony, I recall him saying specifically, he could not recall what information he gathered from headquarters. And so once he came back to Officer Marcel, at that point, Your Honor, to Judge Diaz's point, I'm saying, Judge, if we look at the totality of the circumstances, at the 4-minute mark, we are only beginning to look at the driver's license. At the 8-minute mark, which only took, if you look at the video, only took 1.5 minutes to determine the actual status of the defendant's license. It only took 2 minutes in the computer system to verify that the car was properly registered and had an owner. What we are saying here is that this was an engineered stop. This was a stop to make sure that the K-9 units could arrive in time. And to make time sufficient, the officers prolonged it. Notably, before Officer Marcel takes the license that was given to him by Detective Hagler, and he's told as he gets the license, the K-9s are coming, that is another cue to take your time, slow down. Don't move so fast. And as you can see, if you look at the video, he can actually pulls up, he discovers rather quickly that the defendant had a license that was revoked. And furthermore, When asked, do you need any other information? He says no. He could have obtained that VIN number at that point and kept it there so that he can search the status of the vehicle. Judge, I think this case goes to public policy. If we allow officers to create a timeline or create a chronology of events to permit the use of canines, it has a chilling effect. I mean, what if we have a defendant or a person who doesn't have any narcotics or any illegal contraband in the vehicle? Those cases will never come to court. So I think that we had, in this case, Your Honor, a number of material inconsistencies. So much so that the trial judge indicated that I had impeached Officer Marcel. I would argue if the courts reviewed Detective Hagler's testimony, I think he was impeached thoroughly because he had a numerous amount of internal inconsistencies. But then it leads to the next point, and this issue wasn't raised below or on my brief, and I do acknowledge that. And that is, at the conclusion of the prolonged detention, the trial judge focused on the towing aspect. I think in our brief, we indicated there isn't any statute or local law that provides that a car must be towed. But the issue also became clear that an inventory search wouldn't apply. And we would also argue, even though I know this is on an oral argument, Arizona began the whole issue of you need a search warrant. The defendant and the passenger, look at the video, they were secured on the side of the road. There was no exigent circumstance, and a search warrant could have been obtained. So we would argue, Judge, that based on the totality of the circumstances, the actions of the police officers violated my client's constitutional rights. Thank you, Judge.
Thank you. I think we understand your argument. Hear from the government. Mr.
Thank you. May it please the court, Eric Lindahl on behalf of the United States. This court should affirm the lower court's denial of Perez's motion to suppress. The duration of this particular traffic stop was in no way extended for the purpose of the dog sniff. The officers, in particular, Officer Jean Marcel, worked diligently to accomplish the purposes of the traffic stop in this case. Judge Conrad found that the officers involved did not prolong the stop, and the appellant is unable to point, Your Honors, into anything in the record that would suggest that that finding was clearly erroneous.
Mr. Lindahl, I mean, it's not often the case, as Justice Diaz here, that you're going to have direct evidence of that intent to prolong the stop, but isn't the best evidence of that the fact that these officers right from the get-go understood that they wanted a canine to show up because of the underlying suspicions regarding drugs in this car?
No, Your Honor. I would submit to the court that the subjective intent behind the stop is of no bearing with respect to the legitimacy of the stop. That's a holding that's consistent in Wren that was adopted in this court in United States versus Palmer.
Well, okay, let me make sure I understand that. So I don't disagree with you that the stop at its inception, the subjective evidence of what the officers may have been inclined to do or what the purpose was, it may not be relevant, but isn't it relevant to whether or not the stop was unreasonably extended?
Your Honor, I would submit that there's no evidence to support that it was measurably extended. And if I'm understanding the court, the mere fact that there was a subjective intent that might have induced the stop at its outset wouldn't be support or wouldn't be evidence from which it could be inferred that there was any measurable extension to the stop. Essentially, this stop was carried out in
excuse me, I think my colleague was saying, what about the evidence, the suggestion of the evidence that has been outlined by the other side, that there was evidence of intent to extend the stop to get the canines, not just to, is that relevant for us here?
Well, Your Honor, this circuit has not explicitly ruled as to how it may address a case where there's evidence of deliberate delay. I would submit to this court that there is no evidence from which you can infer a deliberate delay. And perhaps it would be most helpful if I speak to some of those argued delays on the part of the appellant and maybe address what came out in the hearing in a light most favorable to the government. With regard to
let me back you up. I thought what you would say to my good colleagues is not that it's irrelevant. And I can't tell exactly what you're saying, but the fact that they wanted a drug dog to show up is not irrelevant. In fact, it's probably true in every prolonged traffic stop case that we have, right? But that it is not dispositive in any way, because in every case where there's a drug dog coming, somebody wants the drug dog to get there. And so we're really left with trying to evaluate whether their actions themselves did delay the stop or not. Is that?
Yes, Your Honor. I would agree with that entirely, and I apologize if I wasn't articulating that position earlier.
Right, because it's just too much. I don't think the government wants to say that their intent is wholly irrelevant in determining whether the stop was improperly delayed. It's just that it's not all that probative of whether their actions did delay the stop. And that's the fundamental question, is whether they did take actions that unreasonably delayed the stop.
Correct, Your Honor. And I would go a step further and say that there must be some showing beyond just that subjective intent, or that intent in this case, that would be necessary to show a measurable extension for a investigative purpose that was unrelated to the traffic stop. So I would submit that would need to be present for this court to find.
Can you answer a slightly different question? I don't want you to change the subject if somebody has something more on that, but what do we do with the fact that there are multiple officers that are assisting in the stop? So imagine the scenario where, I thought that Marcel, acted with reasonable dispatch and doing what he was supposed to do. But I also can say that he could have acted much quicker had he used all of the resources that were available to him at the stop, right? Because he could have said, hey, Hagler, you do this. Hey, Jones, you do that. Hey, whatever, go do this. And so by dividing up the various tasks, he could have done it in less time. Does our case law require us to evaluate the most efficient way of doing it? This is the challenge that I have when I look at these cases and I say, well, a perfectly executed stop, if we had 4 officers working in synchrony, could have done this quicker. But our cases don't seem to suggest that, but they don't seem to preclude us doing that either. What do you tell me to think about in that context?
Yes, Your Honor. I would submit that the case law at present does not require that this stop be carried out in the fastest manner possible. Again, the cases have been very clear that these officers have to exercise reasonable diligence. And that can mean officer behavior that looks different in the same traffic stop, however, is still being executed reasonably diligently toward the purpose of that stop. So to Your Honor's larger question with respect to the appearance of multiple officers, I would submit that this court's opinion in United States versus Donald Hill is very informative on this point. That is a very analogous case where there were multiple officers involved trying to accomplish the purposes of the stop, where you had one officer, like Gene Marcel, who was in his patrol car, working diligently to pull up the databases that are necessary to investigate what they were investigating and complete a citation. And you had a second officer who was remaining with the defendants and the driver at the car. And the court said that was okay, that there was a safety purpose to that, and also emphasized that Rodriguez doesn't require the courts to second guess the logistical decisions that are made by law enforcement on the scene. It doesn't, in other words, require that we look and take fault with the fact that the registration wasn't requested right out of the outset. So long as these officers are working for purposes that are related to the stop and doing so with reasonable diligence, then they are complying with the Fourth Amendment up to the dog sniff. And I'll tell Your Honor, too, when
Can I ask you about, Ms. Lindahl, about the issue of the registration? And I think it's your colleague on the other side who made this point, that it seems almost rote that when an officer conducts a traffic stop that he or she asks for all of the relevant documents at one time. And the fact that that didn't happen here and it seemed to occur in a piecemeal fashion suggests that there was something else afoot here. That is, that the officers were trying to, drag their feet in order to make sure that they took as much time as they needed to allow the drug dog to show up. But what about that kind of odd sequencing of the documents here, which is not typical in my experience?
Yes, and I understand, Your Honor. And I would respectfully disagree that the absence of a request for registration right at the outset can result in an inference of a deliberate delay, because the officers, again, made the logistical choice in this case to begin by investigating initiating an incidental investigation related to the stop, which was the propriety of the license. They collected the license. And I will tell the court that this is a situation where the stop was premised on not just an expired temporary tag, but also a fictitious tag. So in a scenario like that, the evidence bore out that the VIN number, the vehicle
why does that go that direction? So, yeah, I want to talk to just understand, what do you mean by the fake tags, right? Because if the stop was really about fake tags, then Judge Diaz's point seems even stronger, right? Because that would suggest you'd ask first for the registration, not the license plate. I mean, not the license, driver's license. There wasn't a license plate, that was the problem.
Understandable. The idea being that it's going to take the vehicle identification number to confirm accurately the true owner and registration information on a car that's being operated with a fictitious tag. And the reality of a car that's occupied.
All right, so stop. Help me understand why. So if I get and I don't know these details, but if I get stopped, the way they confirm my vehicle registration is based on the license plate. And so what you're saying is because there were fake tags, they had to get the registration, but they ultimately were going to have to match that up to the VIN number on the front of the car.
That's exactly what I'm saying, Your Honor. It's a unique circumstance with a fictitious tag investigation because you need to determine if that car is stolen and determine if it had its true registration. And the only way to do that, as was borne out by the testimony, was through that vehicle identification number. It also came out.
No, go ahead. I'm sorry. I thought you were through.
So sorry. It also came out subsequently that Mr. Perez was unable to produce any registration paperwork. And I'll note to the court, as reflected in the body-worn camera that's been mentioned earlier, that you actually do see at the 11:50 minute mark, Officer Marcel request of another officer on scene to collect that vehicle identification number. And so that's occurring at the same time as Officer Marcel remains in his patrol car and is continuing to diligently enter information and pull up information from databases. That VIN request has to occur after the car has been emptied of its occupants. And that came out during the hearing as a trial safety measure. So I would submit that while the registration wasn't requested of Mr. Perez at the outset, he ultimately was unable to produce one. And the case law does bear out that the defendant's own conduct can lead to a reasonably longer duration of an investigation that's related to the stop. So here the defendant has...
You have an excellent lawyer's technique of just a single breath, and you can keep on talking for 10 minutes. But I am going to interrupt you now. So we're talking, what was Marcel's basis for suspecting that the tag was false?
Your Honor, Officer Marcel testified that he had engaged in an earlier investigation where he had, actually it was a traffic accident where it had involved one of these more automotive temporary tags from the dealership. He contacted the automotive dealership and was informed that the specific tag was not issued by that dealership. They bear striking differences, and in fact, the joint appendix includes the government's exhibit of both the tag at issue in this case and the Moore's automotive tag, the real true tag that was issued by the dealer. So Officer Marcel was in a unique position based on his earlier investigation to immediately recognize...
Did he testify about anything that he noticed about the Perez tag that led him to suspect it was false?
And Your Honor, could you please repeat that? I'm sorry, I had trouble hearing.
What he did is, I think you're correct. He said it's the only basis that he said was that he had a tag like this at some other, the same dealership, right? Right.
Correct.
That's the only thing he said. That does he say why there's specific details about it, this dealership, that made it suspect to him? He just said he'd seen another tag from this dealership.
That's correct, Your Honor. And
so there's
I think
else.
The focus was on the appearance.
Is that a sufficient basis to find a reasonable suspicion for a fake tag?
Your Honor, I would submit it was. He had the experience of having seen what these more automotive tags are supposed to look like. And I'll also remind the court that this is an expired tag stop as well. So the temporary tag that was fictitious bore the date June 4th, and the stop occurred on June 6th. So it bore it in large lettering visible to Officer Marcel that provided a second basis.
Turned out it wasn't a fake tag, though. It was expired, right? I mean, isn't that the evidence?
It was both. Your Honor, the evidence is that it was both expired and fictitious. That's the evidence that came to light with respect to the tag.
The tag on his car?
The tag on the Passat.
Where is that?
That's correct. Your Honor, it was testified to by Officer Marcel, but I'll also draw the court's attention.
He specifically said it turned out that it wasn't fake.
I think what Your Honor is referring to is that the car itself had a valid registration. Right. It just wasn't fixed to the car, and it wasn't available in the car. So when they ran the vehicle identification number, it came back with a true owner, and it also came back with a current registration. So that was what they determined after they engaged in all of this very methodical investigation into the tag, that when they ran the VIN, it was registered to an individual that was not Mr. Perez.
But a friend of his, apparently.
Your Honor, there's no evidence to suggest who or how this individual was connected, but certainly it was not Mr. Perez, and it did not have any bearing on the fact that the tag that was actually on the car at the time of the stop was in fact fictitious. So that tag was fictitious, but I think that portion of the testimony might be what Your Honor is referring to when questioning about the subsequent discovery that the car actually had a valid registration. It not only wasn't displayed, Your Honor, it wasn't available. So that is why the car was subject to be towed at that time, because there was no opportunity to make it a street legal car, so to speak, with the contents that the officers had at the scene. I believe that bears some.
I'm sorry, not really understanding that. I didn't understand that from the record. So try that me one more time on this.
Certainly, Your Honor.
I thought that the officer, this is Marcel, says he thought the tag was fake, and then it turned out it wasn't. He didn't say
so the way the testimony came out is that he suspected the Moore's tag to be fictitious and knew it from the earlier investigation. Ultimately, at the 13-minute mark, he is able to realize by running the VIN that the car was in fact registered in North Carolina, had a true owner, and a current registration. However, the officers on scene didn't have a plate that was valid that could be affixed to the car. So the Moore's automotive tag, the tag that was the basis of the stop, that was without dispute fictitious, and that has not been suggested otherwise.
So I'm not an automotive expert. So tell me, when you're talking about tag, are you talking about the license plate that's on the metal thing that's on the bottom of my car? Or are you talking about something else?
Exactly that, the plate, the vehicle's plate that necessary to operate the car on the street. So while the database comes back with the information about the registration, there's still no way to make that car a car you can lawfully operate because they don't have the actual tag that belongs to the Passat. I hope that answers.
Well, I hear what you're saying anyway. Thank you.
And I think that the absence of the tag is relevant, as is the fact that the defendant was within minutes of the stop. It was learned that he was operating the car with a suspended license. Because at that point, as Judge Conrad found, the car, it isn't going anywhere. It's subject to being towed. And so certainly...
Well, the license doesn't matter because he has a friend. So if the car can be driven, the friend could drive the car. So it doesn't matter whether he had a good license to drive the car away.
And Your Honor, I think that is one fact that distinguishes this case from Hill, where they were also investigating a suspended license, because it's the combination of the suspension and the fictitious tag, which mean that car is going to remain there on the side of the road until it gets towed. So that bears on the defendant's, Fourth Amendment rights with respect to that car as well, because the officers aren't infringing his movement at that point. He couldn't have gotten into that car and driven away once the officers made that determination.
Have you argued inevitable discovery?
Your Honor, not on the basis of an inventory search. That argument is not being put forth by the government.
It doesn't have to be an inventory search. I mean, it seems to me that you just made an inevitable discovery argument, right? That if the car couldn't leave because it didn't have a plate, then the car was going to be there until either a plate was found or it was towed. And so no matter how long the traffic stop was delayed, the K9 was going to show up in time, right? That's an inevitable discovery, even if you weren't going to inventory the car. Right? It was going to be there long enough to get the K9 there, even if the stop had ended in 60 seconds.
Correct, Your Honor. That could be considered an inevitable discovery argument. I would submit.
What I'm asking is, have you argued that?
No.
Your Honor, I don't know that I did not brief that. No, Your Honor. And I will tell the court part of that is because I also think you can characterize the tow as just a part of the purpose of the stop once it's established that the tag is fictitious. And so that can be considered just as far as the overall duration for the explicit purposes of the stop. And Your Honors, I see that my time is up. I'm available if there are any other questions.
I don't think so. Very much. Counsel, do you have rebuttal? We can't hear you.
I have to unmute, I'm sorry. Can you hear me now?
Yes.
Okay. My colleague referenced repeatedly the Hill case. And I just wanted to point out one of the major differences in the Hill case from the current case. And in Hill, the officers had knowledge that the driver was involved in some robberies. And that provided an independent basis for reasonable suspicion to extend the search. So I just wanted to point that out, that Hill is not totally analogous to the facts here. With respect to the tag issue, I would just point out, and we did not raise this below, didn't come out during testimony, and courts may take judicial notice of this, but I have seen personally in my practice, clients who would write the license plate on the piece of paper, or as long as it was a valid number and visible, and drive away, and many times avoid traffic stops until they can get an actual plate from DMV. The key is the number.
I thought that there wasn't such a thing here. He had written down. I don't understand where that argument goes.
Well, that argument, Judge, is counsel is saying that the car couldn't be operated at all once they removed the fictitious tag. And I'm saying the car was properly registered. We had a license plate. They knew what it was.
I thought you had a false license plate.
There was a it's a fictitious tag. And what happened is
fictitious license plate.
Okay, I'll say it a little different, Your Honor. There was a temporary tag, which is like your license plate, affixed to the car. The government argued that that tag had an expired date on it and that it was fictitious, meaning that the dealer did not provide that temporary tag to that car. However, when they checked the car's VIN number, they determined that the car was actually properly registered with the Department of Motor Vehicles and actually did have a license plate that was not the physical license plate that was not affixed to the car.
And it was not your client's. Your client didn't own that license plate. Is that right?
That's correct. He did not own that car, and there was no attempt made.
So help me understand, counsel. I'm not sure I'm following either, because I thought state law prohibited operating a vehicle without a valid tag or license plate, to the extent that those are different things, but you have to have either a license plate or a tag, and that you cannot operate a vehicle without one, and you cannot operate one with a fictitious one.
Judge, I don't think you can operate a vehicle with a fictitious tag. You can't. North Carolina law is clear on that. In this case, I would argue respectfully that this car did have, this car was properly registered.
But it didn't have the license plate, so it couldn't be operated.
Well, I would argue that, and that this didn't come out below, but I have seen clients write on a piece of paper or something like that, the license plate number, and operate a car.
Wait, your argument is the guy with the fictitious license plate was going to be allowed to write another number down on the same piece of paper, and they were going to let him drive away?
No, he could not do that, Judge. In this case, the appellant actually had a revoked license, so he wasn't going to be able to drive the vehicle anyway. So I'm just pointing out a scenario that could possibly been played out. There are other scenarios too, Your Honor. One being that they could have called the actual owner of the car. Secondly, there was questions as to whether or not the passenger was a licensed driver. But I would also argue that when we get to the inevitable argument that was not made, what is a reasonable time? What is an efficient way to conduct an investigation? Judge, we would argue that 4 minutes before you do anything relevant to the purpose of the stop is too long. And that in and of itself is an important fact. And then when you look at the VIN number, Judge, I think there's New York v. Belton that said that officers can take a photograph or copy of a VIN number from outside the vehicle. Counsel's argument was that the only way the VIN number could have been obtained was if the occupants were removed from the vehicle. We would argue that number could have been obtained sooner. They could have questioned the occupant in the car. Do you have a VIN number? Can we get it? Nothing like that. No efforts were made to that extent. So the argument that they had to wait until the occupants were outside of the car is without merit. We would respectfully submit to the court. I have nothing for the judges unless I have any questions for any.
No, we thank you very much. Unless my colleagues have any questions, we thank you for your arguments, and we will put the case under submission and ask the clerk to adjourn court for the day.
Okay.
This honorable court stands adjourned, signed and died. God save the United States and its honorable court.